The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everybody. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Desmond and Englander. We'll be hearing 6 cases this morning. Due to the ongoing pandemic, we are quite obviously holding this argument by video conference rather than in person. The rules are the same as they are in person, which is to say 15 minutes per side with no rebuttal. The first case we'll hear is number 19-1643, Commonwealth versus Taylor. And we'll hear first from Ms. Dame.
Thank you. Good morning. Michelle Dame from MALIK Taylor. May it please the court. I will begin with issue 1 in my brief that without expert testimony, evidence about DB's changes in behavior was irrelevant and prejudicial. The pertinent question is, was the cause of DB's condition sufficiently within the general knowledge and experience of the lay jurors to allow them to make a causal connection between the alleged abuse by Mr. Taylor and the condition experienced by DB without engaging in speculation or conjecture? If the answer is yes, then an expert is not needed. However, if the answer is no, then expert testimony is required before that evidence can be admissible. The SJC has said that tensions unique to the trauma experienced by a child sexually abused by a family member are largely unknown to the public, and therefore expert testimony has repeatedly been allowed in Massachusetts on the typical symptoms of those children who have been so abused.
Let me ask you this question. Though it's been allowed, has it been required?
I don't think any of those cases actually said that it was required. I think one of the cases just on point here would be Commonwealth versus Amarillo. In that case, the parents testified about behavior their children exhibited during and shortly after attending school, where the defendant who was accused of sexually abusing them worked. The parents testified that the children were crying, experienced headaches, stomach aches, bedwetting, nightmares, loss of appetite, and they were fearful. And that testimony was accompanied by a child psychiatrist who testified about trauma-specific and trauma-non-specific behaviors of sexually abused children. So that case did say that an expert at least was helpful and able to draw the causal connection.
Remind me how old the children were in Amarillo. They were very young, right?
I don't know the exact age, but they were of the age where they were at least attending school.
I think they were in
Preschool.
if I recall, or preschool, yeah. Is it your contention, so the judge looked at this as the evidence is relevant in the sense that a lay person would ask the question, were there changes in the child? And therefore, the fact that there were changes in the child was relevant. And is it your position that it is completely irrelevant without expert testimony?
Yes, without the testimony drawing that connection between, the causal connection between the changes that were experienced and the fact that that maybe meant that he had been sexually abused, that it would be irrelevant. And I think especially the fact of both parents saying that they saw DB pulling out his eyelashes, that is sort of abnormal behavior, and I think something that would require an expert to be able to draw any sort of significance in that testimony. Also, he was brought to the doctor and those medical records were introduced. And I think those records indicated that these maybe weren't unseen problems like the judge mentioned, but actually some difficulties that the parents were having with DB prior to any sort of abuse that was being alleged.
But those are things for counsel to bring out if counsel determines that it's appropriate before the jury and allow the jury to consider it. I mean, we're really just, this isn't a question like a causation issue. At one point in one of the briefs, I think they talk about this as causation. And this is not the situation where, somebody's trying to prove a harm from a tort and they have to have evidence of causation to bring it across. This is simply a relevance question, isn't it?
Again, the pertinent question is whether expert testimony is needed, is whether the cause of the condition was within the general experience and knowledge of the lay jurors. And here it's asking whether the changes in behavior were caused or were due to the fact that he had been sexually abused by Mr. Taylor. And so it is a causal connection here. If he had not been sexually abused, then he would not have had experienced these changes in behavior. So I do think it is that causal connection issue. This also wasn't the typical type of demeanor evidence that is routinely seen in these types of cases, as the parents were not describing behavior exhibited by DB shortly or immediately after either the time that the abuse occurred or the time that he first reported it. And in cases where demeanor testimony has been allowed, for example, Commonwealth versus Arana, there was testimony describing the victim's demeanor the day after a sexual assault. Commonwealth versus Santos described the victim's demeanor the night of the sexual assault, and Commonwealth versus Starkweather was demeanor testimony when the victim was in the emergency room after she had been transported thereafter a rape. Here, the abuse happened in the summer of 2010. The parents say that they noticed these changes in October or November of 2010, so a few months after the fact. However, he was not brought to the doctor until, I believe it was October 2013, so we're looking at a few years after.
Didn't defense counsel cross-examine on the March report that also indicated psychological problems?
I believe it was brought out, and he did make that argument, yes.
Does that alter anything?
Other than the fact that the jury was made aware of it, they would have been made aware of it if they had reviewed the entirety of the records themselves.
Oh, I understand that, but I'm saying here comes this evidence. It's evidence that he was behaving oddly. The inference the prosecutor wants the jury to draw is that it was caused by this abuse. And then you're able to come in and say, they took him for a psychiatric visit in March. This behavior shows how troubled he is, and that this has nothing to do with this alleged abuse. It shows something completely different that actually might explain these false allegations.
I think that just shows that the fact that this testimony wasn't relevant and should not have been introduced. To me, it goes towards the fact, yeah, showing that it wasn't relevant.
I mean, relevance is a fairly low bar, wouldn't you say? I mean, we review for abuse of discretion, correct?
It is, yes.
And so all of these things that you put before, that you're mentioning today, all of that went before the jury for them to determine what, if any, weight it had on their decision-making. Fair to say?
Would have, but without expert testimony, they should not have even been able to draw the inference that it was due to possible sexual abuse. They should not have been able to make that causal connection, and they would have had to engage in the speculation and conjecture in order to reach that determination. The mother also testified about calls that she was getting into the school. The school
I'm sorry, go ahead. No, go ahead. You going to another issue?
I was going to, if there are no other questions on the topic. DB's mother also testified about phone calls that she was receiving from the school, that she was getting called into the school to discuss how he was behaving in there, that he was yelling, not staying still, not listening, and going underneath his desk. Here, this was hearsay. It was the out-of-court statements of the school employees offered for the truth of the matter, asserted that being that DB was actually acting in this way. Hearsay testimony is not prejudicial if it is cumulative, does not undermine the defense, and if the evidence of the defendant's guilt is overwhelming. The only evidence about DB's behavior while he was in school came from his mother, who had no firsthand knowledge of that fact.
The problem there is, counsel, there's no objection whatsoever. And so what you're saying is that the judge was obligated, these answers came out in somewhat non-responsive fashion, actually. Your claim or your argument is that the judge was obligated to, without any help from defense counsel, basically interrupt an answer and strike it.
He should have
substantial risk of miscarriage of justice because he didn't.
He should have, yes, he should have stricken the testimony. This testimony did undermine Mr. Taylor's defense that these allegations were fabricated. This evidence, like the evidence that we had just talked about, showed an inference that he had in fact been sexually assaulted. And again, DB's credibility was the sole issue here. There was no physical evidence. There was no independent eyewitness to corroborate any of these allegations. So both the testimony from his father and then the testimony from his mother about this was both used to draw that inference that the reason DB was acting this way was because he had been sexually assaulted. There are no further questions on that. I will turn to the first complaint issue. A first complaint witness may not comment on the credibility of a complainant. The emotional suffering of a family member is not relevant. In Commonwealth versus Quincy Q, the court found that a father's emotional response or state of mind after his daughter's revelations lacked relevance. And in Commonwealth versus Lorette, the testimony that a first complaint witness was shocked, hurt, and crying should have been struck along with testimony that her father was crying too.
Was there a motion in limine on the first complaint evidence?
I don't believe so.
So there was not a prior transcript. There was not any. Is there anything that told either counsel what the mother was going to say when asked?
Not the specifics like this, no. I believe there was testimony I believe there was a motion to admit her testimony as first complaint testimony, that she was the person first complained to, but I don't believe there are any specifics of what the testimony was anticipated to be. And here, yes, sorry.
So the argument goes, he disclosed to his mom that he had been raped.
Yes.
And she was upset. And that was overly prejudicial to the defendant.
Yeah, she said she began crying and screaming when she was told. She didn't want to know any of the details about it. And it's irrelevant. And how she responded, the fact that she was so emotional and so upset over it, may have actually caused the jury to infer that that was because she believed what she had been being told.
Right, but part of her testimony, the beginning of that testimony at least, is in describing how she got him to tell her what had happened, right? So she says, he wouldn't tell me, and I was screaming, tell me who it was, tell me who it was. And eventually he then gives up the name, Boo Boo. Doesn't that come in as part of the first complaint conversation? Not because it's emotional, but simply because it explains to the jury how the disclosure was made.
How she was behaving before she was actually told and trying to get him to tell her what was wrong. So she was screaming before she actually knew. But to continue with that after she had been told that she continued to behave in this way, continue to respond in this way, and especially I think the fact that she was crying, that would be irrelevant. Maybe if she did it beforehand, a little more relevant to come into the context of the first complaint conversation, but to do it after she had already been told what had happened and he had disclosed this abuse, at that point it becomes irrelevant. She next testified that after DB told her what happened, he went and told his father. And first complaint testimony is limited to one witness and one complaint. The court has said that multiple complaints serve no additional corroborative purpose and in fact unfairly enhances a victim's credibility because a liar may spread the tale widely while someone telling the truth may only choose to tell one person. So here, even without going into the details of what DB had told his father, the fact that she said that a second complaint was made amounted to telling the jury exactly that a second complaint was made. And it doesn't matter if the details were testified to or not.
Even without the details being disclosed to the mom? Correct.
It's the fact that now we have two complaints were made. The jury has heard that DB has told two separate people, and that in their mind could mean he's more credible because if he wasn't telling the truth, he wouldn't tell so many people. And the court has actually said that when you allow these multiple complaints, it unfairly enhances a victim's credibility because that isn't actually always the case. But the jurors do not necessarily realize that. If there are no further questions on that, I would just briefly like to touch on the closing argument. Here, the prosecutor stated that DB's family had nothing to lose because the family had been torn apart and certain members did not speak to each other anymore. What was elicited at trial was that the abuse happened in 2010, but the family didn't actually know about it until 2017. So there was no testimony that Mr. Taylor was an active part in this family's lives for those 7 years to indicate that if their family members didn't speak anymore, that it actually was due to these allegations. So in this case, you have several instances where DB's credibility was improperly enhanced, and the cumulative effect of all of those errors ensured that Mr. Taylor did not get a fair trial. If there are no further questions, I will vest on my papers.
Seeing no further questions, thank you very much. Excellent argument.
Thank you.
We will hear now from your sister, Ms. Nguyen.
Thank you. Good morning. May it please the court. My name is Mary Nguyen on behalf of the Commonwealth. With respect to the first issue, the Commonwealth's contention is that the evidence regarding the victim's post-assault demeanor and appearance was highly probative of the victim's credibility, which the defendant put at issue. The judge in this case did the appropriate weighing of this evidence, and you can find that summation of his analysis in page 25 of my brief, footnote 21.
Do you have a case where testimony like this has come in without an expert?
Yes, and I actually cited a slew of cases, many of which are cases out of this court. There was one SJC case, which was the Sanchez case, which I cited, and that is 405 Mass 369, a 1989 case. And the remaining cases, there are about 6 cases out of this court where there was no expert testimony because it's not required when we're talking about sort of general observations that are made about either a victim's appearance, demeanor, or behavior. A particular case that the judge actually, I want to start first with the case that the judge relied on. So there was case law and authority supporting his position that there was an expert testimony required to make a causal connection.
Was that Solano that he relied on?
That was Solano. So simply, to have testimony saying that the victim behaved one way and then behave differently thereafter, that's sufficient connection. That's the Solano case. And in that case, there was testimony from mother and grandmother regarding escalation of the victim's anxiety after her encounter with the defendant. There was no expert testimony, and that was relevant to the victim's credibility, which was the defendant's theory of the case, was that she fabricated the assault, much like the theory in this case. Another case that I also
Solano was a 128?
It was, Your Honor. It was a 128, an unpublished decision. And also unpublished but persuasive as well is the Santangelo case, which is cited in my brief as well, out of this court, where this court approved admission of evidence of changes in the victim's behavior and demeanor after the rapes, which included testimony from the victim's father, that the victim had been on the honor roll from the 7th to 9th grade, that she was happy, obedient, a good kid, until after the assaults, where there was evidence that he testified that she got in trouble at school, had to be removed because of her disruptive behavior. She did not complete the following semester. She became quite bad. There was no expert testimony, but that evidence, the change in behavior, was deemed relevant and probative as it bore on the victim's credibility. So that is very similar to this case, where the defendant.
What do you say specifically to the pulling out the eyelashes, which seems to be a little bit different than that evidence you're talking about?
So that is still, so my contention is that the cases which counsel cites, those are very specific and unique symptoms associated specifically with child sexual trauma. So in the cases, those 2 cases which she cited with the very young children, in both cases, there was these symptoms which included sexually explicit behavior, such as in Emerald, one of the children kissing the mother, for example. or sort of other sorts of symptoms that were unique and specific. So although one might look at this eyebrow incident as unusual, it's certainly, there's nothing to indicate that it's unique to sexual abuse, so that there would be this requirement that some diagnosis that's diagnostic.
It's eyelashes, not eyebrows, right?
Eyelashes, I apologize. Yes, eyelashes, correct, Your Honor. Well,
no, I'm sorry, you finish.
I just wanted to indicate that this isn't a situation where there was a case that counsel cited where there was dermatitis, irritant dermatitis, where the cause of that might be unknown to a juror, so that expert testimony may assist the jury because that's sort of outside of their realm. This, although unusual, there's nothing sort of diagnostic about pulling out your eyelashes and associating that diagnosis with child sexual trauma. Was the only thing I wanted to.
What does cause someone to pull out their eyelashes?
I'm not sure, Your Honor.
Well, then what makes it relevant?
Well, what makes it relevant is based on the testimony that you got from the parents, which is prior to the sexual abuse, he wasn't pulling out his eyelashes, and then thereafter, shortly thereafter,
so your
he was pulling out his
hypothesis
eyelashes.
is that the sexual abuse made him pull out his eyelashes. Is that right?
I'm sorry?
Your hypothesis is that the sexual abuse, the rape, is what led him to pull out his eyelashes.
Well, that is a connection that the jury can make. So the jury.
Well, your sister says not without an expert. And when I asked you what makes someone pull out their eyelashes, which is something I've never heard of before and seems very disturbing and sad and unfortunate, you said you didn't know what makes someone do that.
So I think the issue, if I'm not mistaken, Your Honor, is that these are observations that the parents made, and they didn't draw any sort of conclusion. Their testimony wasn't,
Well, because they're not experts. How can they draw a conclusion? They actually took the kid to the hospital. They don't know what's going on, right?
Well, so I think that that's important because their testimony is limited to their observations, right? So we don't have anything improper where they're
to the hospital 3 years later.
And that's for the jury to weigh and assess.
No, but is that when did they take? I just looked at the hospital records. I can't make head or tail of them.
So my memory is that they took the victim to the hospital in October of 2013. So that.
Okay.
I'm sorry, the same year as the abuse or years later? I thought it was the same
3
year.
years later than when they placed it, but they had trouble placing the year of the abuse too.
Correct. So the indictment reads sometime during 2010, and then you have testimony from the parents sort of estimating that it was sometime around the summertime. They believe in 2010 just because their other children were playing baseball when they encountered the defendant again. So
is it your proposition that children exposed to trauma may exhibit a change in behavior, or children exposed to sexual trauma may exhibit a change in behavior?
I'm sorry, can you repeat that question?
Is your position more of a general proposition that children who are exposed to some trauma, it's a pretty common understanding, I'm asking, is this your position, that they may exhibit a change in behavior, or is it that people exposed to sexual trauma may exhibit a change in behavior? What inference are you asking us to draw?
Not sure if I'm having trouble. I apologize. I'm having trouble with this question.
I'm trying to distinguish between any trauma and sexual trauma. And so I'm asking you, is it a general understanding, do you believe that people who exhibit trauma may exhibit a change in their behavior? Do you think that that's a general understanding that does not require expert testimony?
Yes, I believe so, if I understand your question correctly. But I think that what my contention in this particular case is that, look, there was some sort of change in this behavior generally that the parents observed. And they're not drawing any conclusions or any diagnostic conclusions one way or the other. They're just saying, look, around this time period, he was acting like this when prior to he did not. And there's been a slew of cases, many out of this court, indicating that evidence similar to that is highly probative, particularly when the victim's credibility is at issue. Is the
Probative of what?
I'm sorry?
Probative of what?
Probative of the contested issue, which is the victim's credibility, which the defendant.
It's probative of his credibility?
Yes, it is a highly contested
And
issue.
why is that? That's because these behaviors are linked to sexual abuse. Right? They're not linked to untruthfulness generally. They're linked to sexual abuse, I gather. Or no, you're not saying that.
So I think that's what I tried to draw the distinction, because counsel relied on that Amaralt and the Dockham case, where I'm saying our case is in opposite to those scenarios, because those were child specific and unique symptoms that are associated with child sexual trauma. That's not what we have in this case. We have sort of general observations of demeanor and appearance and behavior generally that were observed by the parent.
Okay, but that can't be enough, right? Let's say this happened in the summer of 2010, and in the fall of 2010, for the first time, the child says, I'm not going to play soccer this season. I want to play baseball instead. I want to do fall baseball. Well, that's a change in behavior, but presumably you wouldn't bring it in to demonstrate that he'd been sexually abused, right?
Well, so in this case, very much like the Santangelo case and very much like the Solano case, which the judge cited, we have scenarios where there was sort of a change in behavior where the child was happy and prior to, and then subsequently thereafter is unhappy.
And you don't need an expert to explain that sexual abuse can lead a child who used to be happy to be unhappy.
So, happiness and unhappiness, I was trying to sort of distinguish from sexually explicit behavior, for example. I'm just going to use that just because it's a more obvious symptom, right? And so in Solano, which is the case that the trial judge relied upon, that this specific issue was litigated. And this court indicated that expert testimony is not.
This court did not.
I mean the appeals court. I apologize.
No, it's not this court. I mean, they're 128s. They are not opinions of the court.
Well, they're not. Whatever.
They're
have no precedential.
They're opinion of a panel.
Right.
But let me ask you, I'm surprised by your answers. You seem to want to steer clear of saying everyone knows these are things that happen when you're sexually abused, might happen to a child who's sexually abused. And therefore, I don't need an expert. I would have thought that was your argument. But you're saying it's not about sexual abuse, right? You're not saying sexual abuse leads to a child hiding under his desk at school. You're not saying sexual abuse leads to a child plucking out their eyelashes, or can. You're not saying sexual abuse can lead. You're just saying these are observations, but but you don't seem to want to tell me what they're relevant to.
So I'm saying that, and I'm not sure if I'm not being clear, but to me, the probative value, the relevancy has to do with the victim's credibility, which
you
is.
You keep saying that credibility when he says what? Credibility when he says he was raped.
Correct.
Okay. Why do these changes in behavior support that someone who says they were raped was?
So
If
they,
you agree with me that a change in behavior to playing a different sport would not enhance his credibility, why do these ones enhance his credibility?
so I think the point is, and I'm trying to take a step back here. I think the point is that the defendant's whole defense theory is that the victim fabricated the assault. So that's my point in saying that, like, the victim's credibility with regard to the sexual assault is highly contested in
Of
this
course
case.
it is. How
Yes.
does this evidence bolster it?
So it corroborates, right?
How? How does it corroborate it?
Okay, the victim has alleged that he's been sexually abused by the defendant.
Yes.
Before he encountered the defendant during the date of the offense, the date of the offenses, he was a happy kid. And then shortly thereafter, there are observations made that he's not so happy.
So your view is a switch from happy to unhappy may reflect sexual abuse.
Yes.
What about a switch from not plucking out your eyelashes to plucking them out? Well, is that also reflect sexual? Might that also reflect sexual abuse?
It could.
How do you know?
So I don't think that you need an expert for the jury to come to that conclusion.
How do they know?
Well, so they can draw that link, and I know it's not I know it's only for persuasive value, right? But just going back to the Solano case, the nexus can be drawn between the assault and the change in behavior because there's testimony of it being the behavior worsening, if you will, after, and that is sufficient. So in drawing that analysis from the persuasive case Solano, which I know is only for persuasive value, the victim's parents here adequately established the nexus between the assaults and their observations regarding the decline in his appearance and demeanor following the sexual abuse.
So if the events occurred in 2010 and the hospital records are from 2013 that you want to get in, how does that draw the connection that you want?
So
And
I apologize.
I mean, I'm struggling with sort of a really basic problem, which is, you know, you say that they're relevant and maybe they would be if temporally they were connected, but I don't see the temporal connection, at least to the hospital record I'm looking at.
So I do want to address the temporal argument, and I also addressed that in my brief as well. But with respect to that, it's not just the records as a whole is not just isolated to that October 2013 visit, but certainly that piece corroborates the victim's parents' testimony that they make these observations. So their testimony is that they're making these observations.
How would corroborate their testimony that they made these observations shortly after the event when they went in 3 years later? He's 3 years older.
And that, you know, and that's certainly before the jury to weigh and assess, you know, so the victims.
I'm not sure it's just for the jury to weigh. I think that for that kind of evidence to go in, there has to be some indication that it's in fact relevant.
All right, your time has expired. If there are no further questions, thank you. Another excellent argument, very good on both sides. Thank you very much, very helpful to us.
Still with us, Matt?
Yes, the case is now being recorded.
Thank you very much. Welcome to the appeals court. Good morning. I'm Justice Rubin. I'm joined by Justices Desmond and Englander. We are meeting by video conference rather than in person due to the ongoing pandemic. The rules for argument are the same here as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. The next case we'll hear is number 19-1372, which is Commonwealth versus PRINS. And we will hear first from Mr. Kenyon.
Good morning. May it please the court. Joseph Kenyon, appearing for Mr. PRINS, Timothy PRINS, defendant. I would like to focus, at least begin my argument by focusing on the jail call, the admission of the jail call and the related question of the admission of the alleged victim's statement just preceding the jail call and the denial of a mistrial based on the admission of that preceding statement that should not have been heard by the jury. I think without the preceding statement that the trial judge had ruled is not admissible, the statement should not have been admitted at all. The jail call should not have been admitted.
Suppose we agree with you. Why shouldn't the earlier statement by the wife have been admitted? Isn't it part of the rule of completeness to make it, to allow us to understand a statement that was otherwise an adoptive admission, or could that not have been argued?
Well, it might have been argued, Your Honor, but the fact is, the rule of the case was that the trial judge ruled that only the statement of the defendant should have been.
The problem I'm having is this, and I'll ask your brother about it too. If, as Justice Englander suggests, this was propensity evidence without the wife's statement coming in, but on remand, if we were to vacate the conviction on that ground, on remand, both the wife's statement and this statement would come in, not for purposes of demonstrating propensity, but as a party admission, essentially a confession, adoption of her statement, you shouldn't be grabbing at me. And so he doesn't, one might expect him to object to that, but he doesn't. And maybe as consciousness of guilt as well, when he says, you antagonize me and you do it on purpose in response to the grabbing. If that will come in on remand, substantively, not as mere propensity evidence, but substantively, do we reverse and then let that happen? I mean, I would think, I get that it wouldn't be purely for propensity purposes, but it might be worse. How do we figure out the prejudice if that's what we think? And let me also add, just for a second, the judge seemed concerned about authentication of her voice, but her voice is unusual and distinctive. And the jury had already heard it once, the 911 call, and it's pretty clear it's the same person, at least enough for authentication, I think, in the second one. So I'm inclined to think the judge erred in letting in just the statement. I'm inclined to think that it was propensity evidence, but I'm also inclined to think that if we grant a new trial, it's going to come in not as propensity evidence, but directly.
Well, Your Honor, I agree that if you were to grant a new trial, that it could then be argued that, yes, the entire statement should be admissible for completeness, and then it would be the Commonwealth would have a stronger case against the defendant. I can't argue against that premise.
But then why would we reverse this conviction on that ground? You're asking us, or vacate the conviction. You're asking us to vacate the conviction on the ground that the way the evidence went in was improper, but in fact, that evidence could have come in for a much more powerful basis. And really what you're saying is my prejudice is that the jury could have used it for exactly the basis that we may decide it should have been admitted.
Right. Well, but the defendant was entitled to his fair trial in front of the jury. And
Right, well, but
That's
Are
true.
you suggesting that the Commonwealth's conduct was intentional? Do you think they did it on purpose?
I do not presume to judge the ADA's intent. What I did stress in the brief is that the judge's instructions were certainly clear. And I think I recite 4 times where the judge, and it was the morning of the trial. It wasn't.
can I tell you, counsel, I appreciated you laying those out. And I think that was a good way to do it. But I don't know how clear they were. I mean, as Justice Rubin points out, one time he's talking about authentication. He's saying, can someone show me that it's her voice? And as Justice Rubin also points out, the way the evidence went in, we had her voice authenticated on the 911 call in advance of that. So I guess it's an observation. I'm not sure how clear it was.
So again, I ask you, you seem to tell us that it was clear, they told him 4 times. And so are you trying to have us infer that it was intentional? I mean, I'd like a direct answer, yes or no.
No, I cannot make that inference or ask you to make that inference. What I was trying to argue in the brief was that it was clear. The instruction was clear. I don't see how it could be interpreted any other way than that only the defendant's statement comes in.
No, it does seem clear, and the judge recognized that that first part shouldn't have been played and gave a curative instruction.
And then played it again without that first part, correct?
Correct. Yes.
And we can't quite tell how much was played, right, from what we have, how far the thing got.
Right, except that it's so short.
Yeah, it is.
It's only about 10 words on her part. You shouldn't be grabbing at me at all like that. I mean,
Yeah, it's pretty.
by the time anyone stood up to object, I would suggest it had all been stated. But you're correct that we don't have that. So my argument on the admission is that by hearing that introduction, as Justice Englander suggested, that removes, if that statement is in there, then this statement does seem relevant, and an admission and could reflect consciousness of guilt. Of course, they could have been talking about something else. I mean, we don't, we don't know the defendant.
But it's relevant. It's certainly, yes.
Yes. So
No longer propensity evidence. Once you take her sentence, it's no longer propensity evidence. Would you agree with that? It seems responsive to you shouldn't be putting your hands on me.
for him to then say, I have a temper. I agree. It would then, it changes the character of the evidence. Yes, to hear her statement before his statement. Not sure I have more to add on. I mean, I've covered.
What's your best case on the excited utterance point? What's your best case for the exclusion of her statements? I mean, you did a nice job in your brief of laying out law that talks about the immediacy, or the need for immediacy, the need to be responding to an immediate stimulus. But as I read the cases, including the Wilson case that was decided by this court only a couple of years ago, it seems kind of hard to overturn. What's your best case?
I'm attempting to refresh my memory on that at the moment, Your Honor. I would argue that, just give me a moment, please. At the Baldwin case, SJC 2017 would be probably the strongest case, fairly recent, which I quote at some length at pages 26, 27, and the Tracy case, which is a mass appeals case from 2000.
Of course. Was the evidence excluded in Baldwin?
I'm afraid I don't have that.
We can look into that, obviously. I mean, it seems to me that our courts have sort of said one thing, which is that it has to be non-reflective, and then they've let in things so much later that I'm not really sure where excited utterance stands under Massachusetts law these days. I'll ask your brother about that as well.
And thank you, Your Honor. I'd like to touch upon the closing argument of the Commonwealth as well. There were, I think there are two statements that I reference, or two areas of statements. One is that the victim couldn't get back into the house that night because she was afraid, when there was no evidence that she was afraid, and she in fact testified that she was not afraid. So for the Commonwealth to ignore that and just say, well, she was afraid, it seems to be a leap without a foundation in the evidence. The second point in the closing argument, the business about whether there were over 200 calls or not. I think it's not, well, I believe that is a valid objection, that to stress the point that there were over 200 calls. But I think more important is the second half of that argument by the Commonwealth, that this alleged victim was subject to quote unquote months of pressure from the defendant, where the only jail calls that even the Commonwealth had attempted to admit before in their motion to eliminate happened in the first week after the defendant's arrest. So there's nothing, so even if they spoke daily, you did suggest it was about daily or almost daily, that doesn't mean that he was pressuring her. In fact, she denied that he was pressuring her. She said something to the effect that they only spoke about her testimony back in the beginning, which was several months before the trial date. This happened all relatively quickly. From the incident to the trial was only about 4.
What is the exact statement you're concerned about? I'm trying to find it in your brief and I'm having difficulty.
We'll turn to it. Commonwealth said, at the moment I'm paraphrasing, but something about the defendant being subjecting his wife to quote unquote months of pressure. And
it was like a months-long campaign.
After months of still being married.
No.
Being emotionally and psychologically pressured by the defendant to testify favorably on his behalf. Is that what you're objecting to?
That's the passage.
Did she give any on direct examination? She testified for the defendant. Did she give any explanation as to why she was standing out in the snow with no shoes on and crying?
No, Your Honor, she did not. I believe I've covered the points raised. I do argue that the cumulative effect of all of the errors, even if no one or two were considered enough to be sufficient to overturn the case, the cumulative effect would be enough. And I would ask Your Honors to consider that as you evaluate the case as well. If there are no further questions, I will relinquish the 35 seconds or so of my time.
Thank you very much. I see no further questions. Excellent argument, interesting case. We will hear now from you, Mr. Tretyakov.
Good morning, Your Honor. May it please the court. My name is Konstantin Tretyakov from the Middlesex County District Attorney's Office. I represent the Commonwealth. I would like to start with the jail call. Admitting the jail call in this case and was not an abuse of discretion by the trial judge, and inadvertently playing the excluded portion could not have prejudiced the defendant here. I agree with the members of the panel that the ruling of the judge that the victim's statement made on that call was inadmissible. It is at least open to some serious doubt, but it is appeal. I do not feel myself in the position to relitigate the motion of limine in front of the court. So the only portion that was—
Well, you may need to, because otherwise you got a problem with this judge at least. I mean, that statement by itself without her sentence is irrelevant, isn't it? And it's simply, all it's doing is indicating he has a temper, which wouldn't come in.
Your Honor, a couple points in that respect. The jury knew that the phone call, and it was introduced to them as a jail call, was made on March 15th, 2018. That is 2 days after the offense. On the call, the defendant, and they also knew that it was the defendant who placed the call. And on that call, the defendant is saying, you keep antagonizing me and antagonizing and antagonizing, and you know you have I have a temper. Prior to that, the jurors—
They're allowed to infer that he's talking to his wife without any evidence to that effect?
Your Honor, thank you very much for anticipating the next point that I was going to make. In the 911 call that the wife made, in the 911 call that the wife has made, she can be heard telling to the operator when he's asking her, has your husband been drinking? The wife is saying, no, not at all. He just has such a bad temper. The modicum of relevance, which is necessary to admit the evidence at trial under the Massachusetts case law, is not big. It's not a high threshold to cross. And in this case, the combination of the wife's statement on the 911 call and the defendant's statement on the jail call, coupled with
without the wife's statement, what would be the purpose of introducing that sentence from the jail?
Consciousness of guilt, Your Honor, providing the motive for the defendant to strangle the victim.
But the jury would have to be able to find, I take it, that he was talking about the incident in question, presumably speaking to his wife.
Yes, Your Honor. And that would be for the jury to determine. In this case, I would note for the court, the Commonwealth's case did not really hinge on the admissibility of the jail call. As I believe Justice Desmond observed, we are having here a victim who is in her socks in a snowstorm, crying, then telling the neighbor—
This goes to prejudice. That all goes to prejudice. And that's obviously an important consideration if we find error. I'm still trying to sort out if it's error or not. To me, it does read as propensity evidence. Right, when I just read that sentence without thinking about that it was 2 days after the event, just that sentence is him saying he has a temper and maybe trying to blame someone else for triggering it. And that's propensity evidence. You say there is a contingent fact. The contingent fact that makes this relevant as consciousness of guilt is he was speaking to his wife, the victim.
Correct.
That contingent fact, you're saying there is sufficient evidence in the record for the jury to find that fact. That is, there's sufficient evidence to find by a preponderance of the evidence that when 2 days after the event, in a jail phone call, a man accused of strangulation of his wife says this: you know I have a temper, you antagonize me and antagonize me and antagonize me and antagonize me, and you do it on purpose. that there is sufficient evidence to find by a preponderance of the evidence that the other party on the call was his wife.
And in addition to that, Your Honor, what you have just said, on the date of the offense, his wife is calling 911.
Okay, but that's, wait. He has a temper all the time, right? That's the character evidence that is problematic. So saying that he corroborates her statement about his character, I don't think is helpful to you.
No, Your Honor.
Right.
Was there evidence before the tape was played? Was there evidence as to where it came from, or that he placed the call, or who he placed the call to? Was there any of that evidence?
Yes, Your Honor. It was identified. It was authenticated through Officer Jason Gardner of the Billerica House of Correction. He provided the jury with
the phone number. Did anybody link the phone number up to his house?
No, Your Honor. It was linked through the personal identification number that the defendant had while he was committed to the House of Correction.
I understand that they linked it up to the fact that he was the one who placed the call, but my question was, did anybody link it up as to where the call was placed to, so that the jury could infer that he was speaking to his wife?
Your Honor,
the answer I take it is no.
Your Honor, if you are speaking about direct evidence, no, there was no direct evidence, but the case can be, of course, decided any case on circumstantial evidence. And when you have a wife who is saying on the date of the offense, he has such a bad temper, you have the defendant calling someone 2 days after the offense and saying, you keep antagonizing and antagonizing me, and you know I have temper. That was enough, I would submit, for the jury to go over the preponderance of the evidence threshold and to conclude, to infer that the defendant was indeed speaking to his wife. So in that respect, I would respectfully disagree with the court that this was propensity evidence. This was the evidence of the defendant's consciousness.
If we don't find sufficient evidence for a jury to find without speculating that he was talking to his wife, then is it propensity evidence? And what do we do given the possibility? I know you can't relitigate the case here. I guess you'd say if we find it prejudicial, we have to reverse, even if in the end it's going to be a stronger case against the defendant, because that's what the judge said. Just this one part comes in.
Your Honor, I would suggest that the prejudice, now turning to the prejudice analysis, I don't think it prejudiced the defendant
Why can't the Commonwealth argue right now, hey, that was an error? Should have let that first sentence in anyway.
Pardon me, Your Honor, I couldn't hear you.
I don't understand why the Commonwealth can't make the argument on this appeal. You don't have to cross appeal, you won below. Why you couldn't make the argument on this appeal, hey, the judge was in error. That sentence should have come in anyway. You say you don't need to make that argument, and I'm asking the question, why not?
Your Honor, if the court specifically asks me, I would be more than happy to address that, because the statement was not hearsay, it was not offered for the truth of the matter. And of course, under the doctrine of completeness, which the judge, the motion going now turning to the question of whether it was advertent or inadvertent by the Commonwealth, I would just draw the court's attention to page 17 of the trial transcript, the first date of trial, where the judge says, I don't know what the entire phone call is. For the purpose of completeness, it possibly can go all in, but for now, you keep antagonizing me till you know my temper comes out. That's admissible. So it was at least possible for, and I think this is indeed what happened, for the prosecutor to interpret that ruling as saying, well, for the purpose of the doctrine of completeness, the victim's statements should come in.
Well, let's assume, I think we're all going to assume that it was inadvertent. You know, I think the transcript, certainly the prosecutor says it was inadvertent, and your brother is not arguing intentional wrongdoing here. So, okay. So inadvertently, they play this. The problem I'm having, and aside from the fact that you didn't argue this in your brief, although maybe you could have, the problem I'm having is the judge struck the first part. And we yes, say that, right, that's what makes this not a mistrial, presumably. So my question still comes back to, okay, if we have to treat this as coming in without the wife's statement, and if we decide, you'd have to speculate to know, to conclude that it's the wife. why isn't it prejudicial? And you say it's almost nothing, but someone saying they have a temper and blaming someone else for antagonizing them. The wife says he has a temper. Is that not, what do we have to find, that it didn't make any difference or had that slight effect?
I would say, Your Honor, that this, and this is not to sound cavalier, but this was a very strong case for the Commonwealth. Again, just to briefly recapitulate the facts, we have the victim here who is in her socks crying in a snowstorm. She admits to the neighbor, and then on 911 call, which was admitted into evidence.
Case for the Commonwealth where the victim testified that it didn't happen. Can I ask you a question? In her, when she testified, was there an effort to cross-examine her about this statement that in the jail call?
No, Your Honor.
So the defendant admits to the police officer that there was some conflict between he and his wife, and that he
pushed her out of the house.
He denies strangling her, but he admits that he escorted her outside or told her to go outside because she needed to cool off, in his words, out in the snowstorm. So how do we know that his language is more than consciousness of guilt that I put her out in the snow? How do we know that it's consciousness of guilt as to strangulation?
Your Honor, if we are going back to the issue of, or rather, if we are still on the issue of the jail call, the relevant, I think the relevant question is that the defendant demonstrates that he, in that call, has a motive to assault and beat the victim. And the theory of the Commonwealth's case was that the assault and battery was effectuated by strangulation, which is why the victim had all these red marks on her neck that were observed by the officer, which is why when she was just starting to make a phone call, she has difficulty breathing, which also may be characteristic of a person who has just been strangled. So given in light, I think that the defendant's statement on the call that you keep antagonizing me and you know I have a temper goes to his motive and hence to his consciousness of guilt. And going to the previous question that Justice Rubin asked with respect to the prejudice, I don't think the jail call, even if the court decides, which I obviously do not concede, but even if the court decides that it was a propensity evidence, I don't think the prejudicial effect of that evidence, if any, was rather minimal to the defendant, because this was a case corroborated by the observations of two people and the victim's own statement to the 911 operator. I understand that Justice Englander observed that the victim testified that none of that happened, and she tried to blame the mentally disabled patients that she was taking care of for inflicting the wounds upon her. The jury did not believe her, which...
No, that's true. But when you say, look, there might have been error, but I don't think it was that prejudicial because the Commonwealth had an unusually strong case, I have difficulty with that kind of assertion in a case where the victim testified it didn't happen and the direct evidence that it did happen are out of court statements being offered for their truth. Now, that's all I was saying. Can we get to the question that's bothered me since I first picked this up, which is how long is too long before it's not an excited utterance?
Your Honor, in this case, I would say there are cases in Commonwealth, if I recall correctly, one decided by the Court of Appeals where it was ruled that several hours, I believe in that case, there was a victim of domestic violence who was escorted into a hospital, and then she made a statement to either a police officer at a hospital or a personnel at a hospital, and then the court ruled that this was still an excited utterance.
Do you remember the name of that case?
Your Honor, no. At the top of my head, I would be happy to provide the court with the 16L letter.
Several hours can be an excited utterance.
I'm sorry, there's some problem with the clock here.
Yes, there's 43 seconds left on the case.
Thank you.
I apologize.
You can answer the question, of course. You have a little more time.
Thank you, Your Honor. Regrettably, Justice Englander, I do not recall the name of the case. I just remember the facts.
I remember that case too, and I remember wondering how it's possible.
In this case, Your Honor, however, there was, the victim says the very first phrase that she tries to talk to her, when she speaks to the 911 operator, you can discern the phrases husband and 3 minutes. And the victim and the neighbor also testified that the victim was out in the snow for no more than a minute when the neighbor's husband observed her in the driveway wearing socks. So in this case, it was the matter of minutes. And I don't think that the argument that the question of how much is too much for an excited utterance, as important as it is, has this sort of practical, so to speak, necessity in the case at bar. I see that my time is up.
Time has expired. Yes.
Unless the court has further questions, I shall rest on my brief.
I see none. Thank you for an excellent argument, both of you. Each of your clients is lucky to have such a fine lawyer representing them. So thank you.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I'm Justice Rubin, joined by Justices Desmond and Englander. The next case we will hear is number 20-193, Commonwealth versus Mendez. We are hearing argument by video conference rather than in person due to the ongoing pandemic. However, the rules for argument remain the same, which is to say 15 minutes per side with no rebuttal. We will hear first this morning from Attorney Smith.
Thank you, Your Honor. Good morning. May it please the court. My name is Sean Smith, and I represent Mr. PIERO Mendez. This is an appeal from a denial of the defendant's motion to withdraw his plea. The basis of this appeal is twofold. First, that trial counsel committed ineffective assistance of counsel when he erroneously told Mr. Mendez that a continuance without a finding on an assault and battery household member, and then separately on a 209A, would not negatively or adversely.
Okay, let's start with that piece, the ineffective assistance piece. Let's say I agree with you that the judge erred to the extent, I mean, we don't really know everything that she was thinking, but her margin notation suggests that she thought this error could be cured by the colloquy. We all know as a matter of law that's not right. So that's an error. She made no findings of fact that I can see. How are we supposed to, do we have to remand this so that, I mean, I find the affidavit plausible. It's consistent to some degree with what the plea counsel said at the plea hearing about the advice from someone else and so on. The plea counsel was unwilling apparently to respond to you at all when you tried to get in touch with him. And so I could see a trial court crediting that, but don't we have to remand so that the judge can make that finding of fact?
I think remand is definitely a reasonable option, and I think it's an option that this court should take. In the alternative, though, I do believe there's enough information within the transcripts, both of the plea hearing and of the transcript.
Everybody freeze? Can I ask you to repeat yourself? I think you froze for a minute there, Attorney Smith.
Sorry about that. I agree with Your Honors in the sense that I do believe a remand is a reasonable recourse in this case, given the nature of the judge's response. However, I do believe that the information provided in the plea hearing itself, coupled with the information that was brought to light at the truncated motion hearing, I think both of those allow for a further finding of fact. I mean, the information provided in the plea hearing itself shows that trial counsel never spoke to the immigration attorney, even though he was aware that Mr. Mendez was a lawful permanent resident or had some type of immigration status here. He also then relied on Mr. Mendez for all the information that he needed apparently on that issue.
He
And then
says that in the plea colloquy. He says, I heard what the advice was from the defendant.
So if you go to the record appendix, page 100, and I have it here, and if you don't mind, I'd be happy to read it. Let's see.
Well, we know, you can read it, but we know that
Sorry.
the defendant tells plea counsel, essentially, my immigration lawyer says if I get this dismissed, the only way I can kind of get out from under any mandatory deportation is I need to get this matter dismissed.
Correct.
And plea counsel runs with that and says, okay, if we get you a quaff and you successfully complete it, it will be dismissed. And indeed, that's exactly what happened, right?
Correct.
And so far, there's been no prejudice to your client because nobody has moved to deport him. Is that fair to say?
Well, I think the prejudice to my client, I agree with Your Honor, nobody has moved to deport him. In that point, I agree with Your Honor. To say that there's no prejudice, then I would disagree with Your Honor on that issue. I think the prejudice comes from the instability now in his position. You'll see from the plea hearing, he had plans of going to education, having a job.
Okay, so I'm gonna interrupt you for 1 second because I get that. So that being said, however, isn't there a fundamental misunderstanding by the defendant as to what exactly exposes him to the deportation? It's not the quaff for a year. He got no committed time on that case, right?
No, straight probation.
And doesn't the statute speak to a term of incarceration for a year?
So I agree with the Commonwealth on this point. The Commonwealth's brief convinced me, after further review, that this is not an aggravated felony. So therefore, deportation is not mandatory. I would also agree with the Commonwealth.
But it is mandatory because these are both crimes of domestic violence, aren't they?
Yeah, it is. So he qualifies for lawful. My understanding is he qualifies for cancellation if he's able to prove it. He has a window.
Can be deported, but he qualifies for the petition to cancel.
Exactly.
Which
So
he
is
wouldn't
now,
if it were aggravated, but it's not aggravated.
Okay, so this undermines
Can I
your.
just make sure I understand? Sorry, Judge Rubin.
Okay.
Make sure I understand. But nevertheless, the quaff is what makes him deportable, correct?
that is correct.
Changes
The
his,
admission to sufficient facts.
Yes.
okay.
And it's, yeah, okay, but now, all right, so let's now go through what difference any of this makes. Any guilty finding or quaff, admission to sufficient facts, no low plea, anything on either of these two charges leaves him in exactly the same position he is in now, right?
No, I would argue on these. So the Commonwealth makes a good argument in their brief where they say, well, what result could he possibly have gotten on the two cases? I would argue on the first case, which is the domestic assault and battery, that was a perfectly triable case, that he could have gone to trial on that one. No other witnesses, perfect claim. The second case, the 209A, the Commonwealth rightly points out, but we have an admission by the defendant. How is he about to get out of that case? I would put it to Your Honor that it is perfectly reasonable, were Mr. Mendez to be victorious on the first case at trial, that the facts of the second case warrant a guilty file, which is not a conviction for immigration purposes, because it doesn't have that restraint on liberty.
But all I'm saying, I wasn't saying, I was only talking about, all right, so let's go through all the steps here. He pleads guilty. Let's say we conclude, or the trial judge concludes on remand, that in fact he received inadequate advice about the immigration consequences. He still needs to show prejudice from that inadequate advice. There are three ways you can show that. The first is having a decent defense. And you may be right. These are not, certainly to me, the 209A is not the strongest case. He's in the police station when it happens. He's allowed to go with a police officer, but whatever, I don't know. And I feel like we don't really know enough about the assault and battery to know whether self-defense is for real or not. Getting in someone's face, you have to retreat, but we don't have any facts around that. But that's number one. Number two is, could have gotten a better plea bargain. I tend to be quite, we do have cases where the sentence is a year, and if it was 364 days, it wouldn't have affected immigration. And do I believe that, obviously a prosecutor can be nicer or less nice, may think deportation is okay or not. Okay, so maybe you could have negotiated that. But now, no plea bargain to these charges changes anything. Is that right? Because they're both domestic violence offenses. They both leave him right where he is. Neither's an aggravated felony. Both are domestic violence offenses. So unless he pleads to some other charge, and I don't know what it would be.
So a couple issues. He could have pled to simple assault on the assault and battery and asked for it to be amended down in that sense. There wouldn't have been the domestic violence aspect to it necessarily. When I do case,
have you seen that? Have you seen domestic violence cases get pled to simple assault? And have you seen violation of restraining orders result in guilty file unless it was some associate term of incarceration?
I have, Your Honor. I don't mean to be flippant on this. I am normally a litigator in the courthouses, and I do these cases on occasion. And I can tell, Your Honor, I've had more serious cases with worse facts. But of course, that depends on a willing prosecutor. Maybe the complainant in the case also doesn't want the individual to be deported. Maybe there's a number of factors that come into play. And I'm not trying to say what the prosecutor would have done in this case per se, but to say that I have seen and have personally witnessed cases that are more.
Let me ask you this. Knocking it down to simple assault doesn't make it not a domestic violence crime, does it? That is, I can't tell under the federal statute whether what it's saying is, and it's, a crime of violence where it's against, I think it says where it's against a spouse. I don't think it says that's charged as a domestic violence crime. It just says right. And this, there's no way around it. This is an assault on, if it's an assault, it's an assault on a spouse.
Well,
right?
I would say 2 points. One, I don't want to forget that a guilty file is a perfectly acceptable.
Yes, I understand, but he'd need it on both, and who's going to give it to him on both?
Agreed. That's why I proposed the trial on one and the guilty file on the next. That being said, amending it down, immigration authorities must go through what's called a categorical analysis or a modified categorical analysis, just as if in terms of matching up federal law crimes with state crimes. And whether or not they can uncover, if the plea is done correctly in terms of the green sheet, and it's put on there that there is straight assault, not household member, or protecting in that way, there are ways to make sure that the individual is protected. But again, I'm not so sure a prosecutor in this case would agree to that, because of course that would require the prosecutor agreeing.
All right, and then the third.
Sorry, can I ask a question? Thank you. Can we just go back for a moment to how you proved this up? You have the affidavit from your client. Did you ask for an evidentiary hearing? That's question number one. Question number two is, did you subpoena the attorney who has the other incredibly critical evidence in this case?
I did not subpoena the attorney. I did not ask for anything more than to be on the papers type of hearing.
So, so your case is basically the lawyer made affirmative misrepresentations as to the law, which were critical to my client. And you think that we can, and that a court could decide to vacate a judgment of conviction after a plea based solely on that affidavit and without any evidentiary hearing whatsoever?
I think uniquely the transcript of the plea hearing provides the evidence to suggest that this trial counsel failed to be competent when it came to advising his client on clear and accurate immigration advice. What he would say on the stand in terms of if he would admit to it or have some other answer to it, I don't know, but I can tell you.
Him saying he had an immigration lawyer is sort of per se error?
He had an immigration attorney that if you look on record appendix page 100,
let me just make sure you understand my question, counsel, because I think it's important from my perspective, at least. I'm with you if you prove that there was a misrepresentation by his plea counsel as to what the law is. That I'm with you with. But if your argument is it's enough to just show that plea counsel relied on the fact that he had an immigration lawyer. You need to cite me a case.
That's not my argument, and I apologize if I'm making that argument. My argument is twofold. One, you could look at the transcript of the plea hearing, and it's provided on Record Appendix 100. You can see the conversation that the attorney said, the trial counsel. Trial counsel said, I understand he has an immigration attorney. He has spoken to that immigration attorney. I believe we're all set. And then if you go on to the plea counsel, you'll talk, there's no information about, oh, the immigration consequences. He talks about my client then going on to go to finish his schooling, to continue on to a career, and nothing.
Right, he literally just says he has an immigration lawyer, we're all set. And I think he suggests, and by the way, it's not, and for me, it's a different page number, so I'm struggling to find it.
Oh, 102, I'm sorry, Your Honor.
No, that's not where I have it. Shoot.
102 in the appendix or the?
In the Record Appendix, 102.
Oh, I see. Yeah, hold on.
It should be lines 16 through 20.
Have you reviewed it? 16 through 20. On immigration consequences, he's a permanent resident. He has private immigration counsel and has discussed the consequences with that. So I have covered that with him. All right. No, I take it your point is not there's some problem with having immigration counsel. It's in what you need to sort of put the ribbon on it or whatever is the affidavit, right? Which
Correct.
says he acted as though a quaff with a dismissal was going to be the same for me as a dismissal. Now, I do think a judge we say judges can discredit affidavits. I suppose the judge could credit the affidavit, and there's enough there without subpoenaing the guy that the judge could, but that's why I would think you'd have to have a remand.
Understood, Your Honor.
All right, your time has expired. Are there more questions, judges? I see none. Thank you very much. Very interesting case and very good argument. We will hear now from Attorney Lee.
Good morning, Your Honors. May it please the court. My name is Chi Lee, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Although
would a quaff for 364 days made any difference?
No, not in this case. So in this case, the only possible outcome to avoid immigration consequences is dismissal of the case or a guilty file, which requires Commonwealth's consent pre or post trial. And from the record, it's very clear the Commonwealth really values the conditions imposed on the defendant. So the Commonwealth would not have agreed to a guilty file where conditions is not available at any time.
Okay, but this just goes to whether he could have gotten a better plea. There are two other spokes to this, whatever it is, the
other two have two factors.
To the prejudice piece of it.
Correct.
You know. All right. So, and those
I'm here
are
for, Judge Rubin.
What?
I said that's what I'm here for, just to help you out a little.
Thank you very much. That's why I'm lucky to have you there. The two other prongs are fight the case because it's not that strong a case, and special circumstances. There are some circumstances listed in the affidavit. It says he came here when he was 11 and it's the only home he's ever known. I agree with you. It doesn't say, and all his family members are here. But again, that might be something to be looked into on remand, whether that's enough to be a special circumstance, or I suppose there might be an evidentiary hearing where if indeed counsel's representations are true, and of course I don't disbelieve counsel's representations, the evidence that his whole family is here now could come in. And, you know, if he was brought here when he was 11, he might have, but he probably didn't come here alone. And so it wouldn't shock me if his family was all here. And that might be special circumstances. I think there are cases where we've said it is. I don't know if that's as a matter of law or not, but okay. And as for the weakness of the case, again, we aren't really in a position with just this police report to be able to tell. I do think the 209A, maybe it's a clear violation. It's a very odd circumstance. he's allowed to go with the police to the thing, and he's meeting with them about it, and the uncle calls to arrange it, and that is a violation. But it seems, maybe I'm missing something and I don't know the background facts. Maybe that's terrifying to the victim, and if it is, then it is. I have no quarrel.
Crime.
Excuse me, Your Honor.
It's enough just to ask someone to make a phone call, even if the phone call is, I want to come pick up my stuff.
No.
Correct, Your Honor. So the PIERO element does not require any intent or specific intent to intimidate or harm the victim. All you need to do is any technical violation of the RO would be sufficient for a violation of restraining order. And that's what happened in this case. The defendant used his uncle, his friend.
The prosecutor has discretion to make the judgment that that's not much of a crime and not prosecute it, right?
That's correct. And
they
the
also have
prosecutor
the discretion to file it if they decide to prosecute it in a plea context?
That's correct, Your Honor.
So, all right. But so I guess my bottom line is, I assume you agree that the judge's reasoning is not adequate. The written reasoning is not adequate to support what the judge did.
I disagree, Your Honor. I understand the judge's one sentence statement might be concerning because if you read it with the motion hearing, that might be concerning. She might confuse immigration warning and Padilla obligation. However, in the defendant's motion, it's on record appendix page 70, he did argue, quote, the plea colloquy failed to inform the defendant that his plea would result in his near certain deportation. The judge's one sentence note about colloquy was done could respond to that argument. Also, during the motion hearing, you can see the record appendix 143 to 144. The motion counsel there cited to Commonwealth de Jesus as a JC case and pointed out the case law imparts a duty on counsel in addition to the colloquy. So the judge was advised by motion counsel, defendant's motion counsel, that there were separate issues.
The judge didn't say anything. I don't see how that written order can support the denial of the motion without at least saying either, I find it's a fact that he was properly informed by the counsel, which if she did find that, there's no reason to write that second sentence. So I guess that's not what she found. Now, maybe well, in fact, if she found anything about the colloquy.
I'm sorry, couldn't she say, you failed to carry your burden on this motion for a new trial because you've made no effort to bring in the other critical witness?
Sure, but then why write? But then why also write? And I gave a perfectly good colloquy.
My response would be because the defendant did talk about colloquy in his motion, the judge was properly addressed that issue.
But all right, so she addressed it by saying what? No, my colloquy was good enough to cure any error. But of course it can't be. And it wasn't. I mean, I don't think a colloquy from the judge ever takes the place of the lawyer's advice, but also she said you may be subject to and you might be automatically deportable. And, you know, I don't know what the proper advice was, but that isn't it.
I think the best way is not to read too much into judge's order and just follow this court's decision in Portillo in 2018.
Okay, but what is the point of affirming? What's the point of judicial reasoning? Of course, we pay careful attention. Read it. It's not even reading too much into it, just reading it.
I think the point is.
But you object to a remand, I take it. You don't think a remand is necessary here.
Correct, because the record is clear that the judge would have properly exercised her discretion in this record. Because
but she didn't. Don't we have to let her, in the first instance, decide how to exercise that discretion if there's discretion?
This court did affirm denial of motion for new trial where there was only marginal order without any factual findings in Portillo. I understand it's an unpublished decision, but this court could follow that panel. And
counsel, so here's the difficulty with that. Yes, we can affirm on any ground supported by the record. But it seems to me that you have an affidavit in front of the judge that says he misrepresented to me what the law was. And because of that, I pled. And if that's accurate, then there's an argument here. And there's nothing else in the record that tells us it's inaccurate. the plea colloquy does not tell us it's inaccurate. So what we would have to do if we're going to affirm on that basis is we would have to decide that essentially she made the conclusion that they failed to carry their burden because they hadn't brought the other lawyer in or subpoenaed the other lawyer to testify.
I agree. There's
Your
a
argument?
no, Your Honor. I agree that there's a gap. The only evidence to show that a quaff will cure immigration consequences is the defendant's self-serving affidavit.
Every affidavit is self-serving.
I agree, Your Honor.
What can you do? There's only two people who know about this, and he's one of them. And this isn't one of those cases where we don't have any evidence at all about the failure of the plea counsel. Appellate counsel or motion counsel filed an affidavit saying, basically, I've called this guy 6-7 times. He responded once, didn't follow up on what he said, and then refused to return my calls. It's not quite as strong as some we see where they say, I asked counsel for an affidavit, but she wouldn't give one, which we tend to think implies that she doesn't want to admit an error that she knows she made. It's not quite that strong, but there is an inference there that this guy doesn't, oh, you want a motion for new trial where I represented the guy? Maybe I won't call you back. That's not how I would hope lawyers would behave, but.
I agree, Your Honor, and this case in this court do consider it as a factor favor the defendant, but the defendant could have subpoenaed plea counsel, or he could have subpoenaed or get an affidavit from immigration counsel to provide exactly what was the advice given to him, so it could shed some light here, and the defendant did not carry his burden. And this court can uphold.
Immigration counsel gave the right advice, and immigration counsel would not have had any information as to what advice was given by the other lawyer. The other lawyer's advice is the critical advice.
That's correct, but from the plea transcript, it's clear that plea counsel can defer to immigration counsel's advice.
So is that enough? Do you have a case that says plea counsel can defer to some unknown immigration counsel who they had no direct conversation with and say, hey, client, you go talk to the immigration counsel, then you come back and tell me what he told you in legal language, come back and tell me, and we'll go from there. Is that enough?
I don't have a case to support it around the country or in federal courts, but I do believe that an ordinary fallible, I believe it's because it might not be an error, because it's very clear if an ordinary fallible criminal defense attorney is relying on a professional expert on immigration law, that should be sufficient.
I gotta say, I think you cite the dissent or concurrence by Justice Cordy in De Jesus.
Correct.
But it's a dissent.
Yes, Your Honor.
So, and I don't think we're going to begin going around saying an ordinary fallible criminal lawyer can give wrong advice on immigration to their client in light of De Jesus. I think that's
or no advice. Did he give any advice on immigration?
Well, we don't know from the record. However, this court can upheld
the affidavit.
Sorry, we do. We have the defendant says, I was told that this would be sufficient and that it would not have immigration consequences for me once it was dismissed a year later. That is in the affidavit.
That's
from
correct.
Immigration counsel. Do we have any advice from plea counsel?
No, that's from plea counsel.
That's from plea counsel. That's correct. And we don't have any information.
The immigration counsel said you have to get it dismissed. And the allegation is that the plea counsel said, oh yeah, this is a dismissal.
That's correct, Your Honor. But the judge, the motion judge was also entitled to discredit any affidavit in front of her.
I couldn't agree more if she had.
I mean, yes, they get to exercise their discretion, but I mean, there's nothing that leans against it in this record. That's the problem. I mean, this record seems to me that it's potentially perfectly consistent with what the defendant said.
Well, one point is bias. The other point is when the motion judge asks why the defendant came forward here when there was no notice of deportation, like how did he know about all of this? The defense did not give a response. The judge was able to take that into consideration, and this court can uphold the judge's ruling on any ground, even on the last prong of
But we
Padilla,
can't
where
find
it's
facts. We can't find a fact that wasn't found below and affirm. I mean, maybe if on the papers or something, but this is a credibility question.
I agree, it's a difficult case, but a reasonable person in the defendant's position would not have gone to trial. The Commonwealth's case was credible, and he knew that it wasn't, or at least he in
What
his
are the
position.
maximum punishments for these crimes? Do you know?
2.5 years in the house.
For both of them?
Correct. That would be the maximum
And
sentencing.
this person had no record before.
That's correct, Your Honor. And he did receive a benefit, which is getting the quaff in the state, which would not be a
Sure, but
conviction.
length of sentence would not have affected his immigration consequences. I mean, not that anyone wants to go to jail, obviously,
I
but
don't know, if he goes over a year in jail, he's
no, it's not an
aggravated and he's out.
That's
is
correct.
this an aggravated? Oh, I see. Well, he's already out because these are domestic violence crimes. Doesn't matter.
He has the ability to petition for.
Oh, because the violent crimes are not under the LPR thing. They're mentioned in 212A, so it's not okay.
Right. So
I think
this
how sad
sound like
it is that we know all this, but all right, good.
this is unlike any other case where defendants usually is convicted of a drug crime, which is an aggravated felony. Here, the defendant had an opportunity to apply for cancellation if he was subject to removal proceeding. And even he's excluded from the US, he can return after 10 years. This is not a case where he's excluded from lifetime.
Because he's an LPR, he can come back after 10 years?
No, it's because he's not convicted of an aggravated felony.
It's not an aggravated felony.
Right, so
Just
this court can,
I see. So going to trial, there is also the risk of a punishment longer than a year, but there's also, well, it'd be better if he'd gotten the right advice, then he could have made a rational decision.
right.
I mean, I don't know what he's going to be sentenced to after being convicted at trial. He has no record, so I don't know.
And even if this court is unwilling to affirm the judge's ruling, a remand will be appropriate at that point.
What we do know is if he goes to trial, he cannot get the benefit of a co-op. We know if he goes to trial and loses, it's going to be guilty something.
That's correct. And if you were to file the case, it has to become with Commonwealth's consent. And on the record, it's clear Commonwealth will not have agreed to a guilty file.
Okay, it's a very interesting case. Your time has expired. If there are no further questions, it's a very interesting case to me. Thank you very much, both of you, for.
Excuse me.
The case is now being recorded.
Welcome everyone to the appeals court. I am Justice Rubin, joined today by Justices Desmond and Englander. The next case we'll hear is number 20-249.
Now being
DC.
recorded.
Welcome everyone to the appeals court. I am Justice Rubin.
Someone has the feed on, they gotta turn that on.
Yeah, is someone have the YouTube channel open at their place? Let's close that. Have we figured out what that is and it's
It was
stopped?
me,
Okay.
guilty.
All right. The case number 20-249 DCF versus Mother. I'll remind the attorneys this is an impounded case and therefore names should not be used. We are doing this by teleconference because of the pandemic, but the rules are the same, 15 minutes per side. I'm informed that DCF and the child will be splitting their time. Excuse me, my understanding is that it's 10 minutes for DCF and 5 for the child. Is that correct?
Yes, Your Honor.
Okay, very good. And we will hear first from counsel for the mother, Ms. Contertesi.
Please the court, Adriana Condertesi for the respondent appellant mother. In this case, we see DCF and the juvenile court going to new areas of unfitness, which completely surprises me. And specifically, that is that mothers having missed a few meetings, testifies to not having kept a calendar, is going to result in an unpredictable and unstable schedule for the child. If that isn't indicative of the entire tone of really the absence of any real evidence of unfitness, I don't know what is, but I know for sure that that is not a grievous shortcoming. And I think that mother, a young mother, should have been given that extra little time that she had asked the court for. I think one of the biggest reasons why is that when you look at the findings, the judge just did not have that much, if anything, to hang her hat on.
You think there's no evidence of an unfitness here? The child's been removed from the mother for 3 out of the 4 years of its life as of trial. No evidence of unfitness?
Think about, may I refer back to when the child was removed the second time? The child was left with an extremely appropriate caretaker, my client's essentially mother-in-law, the paternal grandmother. When mother was late picking the child up after an agreed on sleepover, paternal grandmother called DCF to report her. Before DCF could get over there, mother arrived at grandmother's house to pick up the child. Now, that's not laudable behavior, but I don't think that
She did the same thing a couple weeks later, only she left the child for a week.
No, at that time, the child was removed.
Yeah, there's nothing in the findings that explains the child isn't removed that night. There's nothing in the findings that explains why the child is removed the final time when the child is removed. Is there?
No, there isn't. I mean, there's just.
I'm sorry, counsel, maybe I misread it, but I thought I saw it 3 times in the briefs. There was an incident where the paternal grandmother called and said she hasn't come to pick up the child. She was supposed to come early in the morning, and then she never called, and she didn't arrive for several hours later. But then my understanding was that the same thing happened within a month. She left the child with paternal grandmother for a week. And during that time, the child fell and broke their arm and they couldn't reach mother. Am I making that up?
Well, I know that the child fell while in grandmother's care.
Yeah, I thought that the child had been transferred to grandmother's custody. And it's true that they couldn't find the mother for a week or something. They couldn't get her consent for something medical, but she was not the custodial parent at that time. It was my understanding. But I'll ask your sister and brother about the facts about that. Let me ask you this. If we agree with you that the way the judge wrote this is inadequate, but we also think, well, in the record, there are sufficient facts that might warrant a finding of unfitness. Do we simply remand it? Is that what we do?
Well, I have asked, and my client has asked for what the judge should have done in the first place, and what is often done in probate and juvenile courts when parents go in seeking custody or visitation. Call the parents' bluff. Okay, I will give you 3 months. If in 3 months you have
well,
not.
She didn't really ask for 3 months. I have to tell you, I don't know why everyone is agreeing. Maybe I misread it. I didn't read her to say she didn't want custody right then. I read her to say right now, I don't think the judge would do that. Right. And a few lines later, I think she says, if she could do it, yeah, I want the kid. Maybe I'm wrong though.
Well, I think that you're correct. And that's at transcript page 93.
I mean, it seems to me that obviously there is some substance abuse issue at some point in the last 4, now I don't know how many, but at the time of trial, because there was apparently drug, although no positive screen of the child, drug use during pregnancy, including cocaine. Okay, she does an evaluation. No one tells us how it comes out or what happens, but the child is returned to her. The child is taken away again. I'm not sure I know why. I thought it had something to do with leaving the child for too long places, but it doesn't seem to happen the night of the late arrival. So I'm not sure I understand what happened there. I mean, maybe it's in the record, but I didn't see it in the findings. The child is removed again, and she has service tasks that include substance abuse evaluation, mental health evaluation. Again, I would need to know better than the judge tells me, although DCF tells me some stuff that they don't, and the child's lawyer does too. I would need to know more about exactly what her unfitness is, but it doesn't seem unreasonable if it's this, doesn't show up out in the community till 2 a.m. with the child, with some boyfriend, something. If it's this kind of failures, then I think it's fair to ask, is this because of drugs? Well, why doesn't someone show up for a day? Are they irresponsible? Are they on drugs? What's the problem? And she hasn't done any of that kind of thing. So it seems to me possible that she could be properly found unfit. But as I say, I don't think the judge has really put a ribbon on this or, crossed the T's and dotted the I's.
I agree. I agree that it's possible mother could be found unfit, but that is not the evidentiary standard that we are looking for. This is a giant takeaway of a liberty interest. And we know that it took DCF almost a full year of visits with that mother to make the child stop crying when she had to separate from the mother. A full year.
There are mothers who children love and who are very good when they're with their kids, but who disappear on them to the point where they can't be trusted. I mean, I just read the facts as stated in the brief of DCF, and I had it exactly right. Okay, she not only didn't show up once, for a period of over a day, unfindable by the paternal grandmother, which led to a 51A. She remained with the child, and 1 month later didn't show up for 7 days, during which the child fell, broke her arm. She was unfindable. Now,
I thought custody had changed by then.
No, they had not. That was the precipitating event for the temporary custody order, was the second time that she literally dumped the child and was unfindable. Now, are you telling me that either A, didn't happen, which I'll listen to, or B, is not evidence of unfitness? Because it seems to me that if you're a child's mother and you're unfindable, that becomes a problem. And that seems to me to play into other findings in the record that suggest that she is undependable with respect to this child. She missed something like 40% of her authorized visits the second time around. You do a very nice job in your brief of suggesting that's not what's going on, that, they've overstated it, but the DCF literally lays out what the numbers are, and it's almost 40% of her visits.
Well, Judge, out of
70, the record, counsel?
Yeah, out of 72 visits, mother missed 12. I went through DCF's brief, and Judge, I do want to apologize that I missed that about the week at paternal grandmother's house. But may I point out that paternal grandmother was not an inadequate caretaker. Just because mother couldn't be located at the time paternal grandmother called her, does not mean that mother was irresponsible. Parents leave their children. Yes, Judge, sorry.
Was the father found in the paternal grandmother's home? And he wasn't supposed to be near kids, right?
In June, Judge, and at that same time, other children were removed from the paternal grandmother's home, which tells me that the paternal grandmother was taking care of more than one grandchild.
But perhaps not adequately.
Well, no, the reason why the children were removed from paternal grandmother was that the father had been released on a GPS bracelet for an incident of
Statutory rape.
yes, but with a teenager, with like I think a 14.
I get it. He's supposed to be away from kids 16 and under, and he's at paternal grandmother's home. I'm only speaking to your point, which is grandma was a perfectly suitable caregiver. I'm not so sure.
Well,
Can I ask
don't
you-
think, and I think the grandmother specifically said, I didn't know that he was being released to my house. And I think she did even make him sleep on the porch.
These are facts we can't find. But let me ask you this. A lot of the judge's weight seems to be on the developed bond between the child and TL. I understand it goes beyond the record here. You hint in your brief that they're no longer together. The child's counsel hints in his brief that they are. Do you know what the story is?
I know that the pre-adoptive home did not know that she would lose the subsidy if she adopts that child. And that has changed the picture of this planned wonderful adoption.
Is that in some other court proceeding that we know about? Like, is there something we can take judicial notice of about that or no?
I think, I have had this ongoing problem, and I understand that in the adoption plan, DCF adds this boilerplate language that, well, if that doesn't work out, we're just gonna.
Well, I agree, but I'm not even talking about the sufficiency of the plan. I'm talking about the finding of fact that rupturing the bond between the foster, I think she was a foster parent, the pre-adoptive resource, and the child would be detrimental to the child. And while I understand that you can't exactly bootstrap a removal into an adoption because of the natural tendency of any child to bond with a parental figure at these ages, it's not nothing to think about ripping a child out of a home that she's known since she became sort of conscious, right? So it's a tricky matter. But if someone represented to me that she's not going to stay in that home, I've heard you say maybe she won't be legally adopted, and I'll ask DCF about that as well. But is it your understanding this child is still in this same home?
Judge, I don't know. I think that
I'll ask the child's counsel. I know it goes beyond the record, but I find these, I find these things very significant for the child's life. And I've seen cases where DCF has said what a great match it is, and then we come in and someone points out that the child set fire to the home and is no longer there. That's I've had that case. So
that something happened to the pre-adoptive parent.
Yes, but it's not clear to me the difference between guardianship and adoption is necessarily critical. I just want to know who's going to raise the child.
Well, let me point out, Judge, first of all, that oh geez, I lost my train of thought. First of all, I think that. Pardon me, Judge.
Was the most recent placement, was that a kinship placement?
You know what? It is a paternal kinship placement. So I think that if the child is returned to her mother, her biological mother, where I know that all children ultimately want to be, she would be able to still be in touch with the cousins and with the.
Well, this goes beyond, right? We're not going to, on that basis, a trial court would have to look at that kind of stuff.
But Judge, in what you were referring to, it really has bothered me for a long time, the way that DCF encourages a court to detrimentally rely on a particular parent. And then you see it in the findings, how great that parent is. And then later on you find out. But so I think almost that if you want to consider the parent a third party beneficiary of this adoption plan, then I think it could be.
No, the child is the beneficiary of the adoption plan, the only relevant one, in my view.
Well, so nonetheless, but the bonding is the idea that, well, she's been there for such a long time, so mom loses. That is completely contrary to Ilona and everything that's relative to the liberty interests of a biological parent.
I think there's a question for you.
Yeah, I do, although it may be too open-ended but this really struck me. In the child's brief, they go through systematically each of the items on her service plan and address whether those items were or were not followed by your client. And honestly, it's the only place where I found it done in this way so that you could go through it. And it's striking how many, according to the child, how many of the things that she was committed to do, she did not do. So my question for you, and if it's too open-ended, I totally get it.
Yes.
Are there things you would point us to in that aspect of the brief where you'd say, no, that's not true. She did do this, she did do this?
Well, Judge, I think what I argue in my brief is that so many of those tasks did not necessarily correlate with these points of unfitness that DCF had. And she had done all these programs a year before. And then finally, I think that mother's testimony was consistent with the testimony of a fit parent. I mean, both petitioners make such a big deal out of the fact that mother said, well, yes, my child can kind of read. Well, I mean, that is what a 3-year-old can do. I don't think that mother had any issues with being able to care for this child or understand this child and be with this child. I think that she had the family supports DCF was looking for. As a matter of
Okay, your time has expired. I think that you've answered
I just
the
have
question.
never seen such an unfair case of a finding of unfitness, and I hope
we
the
will
court
hear-
will remand.
We will hear from opposing counsel on that matter. Attorney
you.
Kaplan, on behalf of DCF, you are up.
Good morning, Your Honors. Elizabeth Kaplan for the department. The mother in this appeal was not able to reliably care for this child over the first 3 years and 8 months of the
Okay,
child's life.
this is the problem I have with this case, and I hinted at it or maybe said it explicitly when your sister was arguing. I have now looked again at your brief to the pages that Justice Englander points out. They make a very solid case for unfitness. The citations throughout that section, of course, are to the exhibits, not to any findings of fact. The judge took a year, I guess, to write this opinion, and it's completely lame in my view. I've seen hundreds of these cases, and she doesn't even put in all this stuff. Like if you read, well, I did. Here's how I prepare cases. I read the opinion below first, and I read it, and at the end, here's what I thought. What is her, obviously the judge concluded something. What is the unfitness here? I was left wondering if it was organizational skills or something. I had no idea. Then I read your brief. I mean, I read the briefs actually in order. I read the appellant's brief. Then I read your brief, and I said, oh. But none of that is in the judge's opinion. I don't think the judge's opinion shows by clear and convincing evidence unfitness. I'm not saying it couldn't be supported here. It's just, I just don't think it's in the opinion. So what do I do?
So I have 2 responses to Your Honor. First of all, I do think Your Honor can affirm on the basis of the judge's opinion, where it is clear that the primary concern, well, there's 2 aspects of the primary concern. One is this repeated leaving the child without a willing and able caregiver.
To look at your own citations. There is only one finding, and it's about leaving the kid from morning till night. The judge doesn't put in all this other stuff.
So the second aspect of my answer to Your Honor was going to be that if Your Honor finds that this case can be affirmed on this record, but that the judge simply didn't write findings that were detailed enough to make that clear, the matter can be referred to the juvenile court to write more detailed findings based on this record without necessarily taking further testimony. And if Your Honor is looking for an example of that, I would point Your Honor to Care and Protection of Lilith, which I can provide the specific citation for if you'd like it. It's 61 Mass App Court 132. That was a case in which the court remanded to the juvenile court to clarify the juvenile court's findings regarding domestic violence, which were not apparent, yet could be affirmed on the basis of the record. And that may well be what is warranted here, but
Do you disagree with me? Have I missed, maybe I read it too fast or something, but I just didn't see findings in there. And then I read your brief and it's chock-a-block with evidence. Am I
So-
misreading the opinion, or did she credit certain things maybe at the outset that I didn't?
So I think Your Honor is accurate in terms of reading the findings, and that with respect to the incidents that occurred in March and April of 2017, that those incidents are conflated in the findings. Justice Englander was correct when he stated that there were 2 incidents in which mother left the child without returning when mother said she would, and that in the second of these incidents that the child actually broke her arm while she was in the paternal grandmother's care and mother couldn't be reached.
But not,
unfortunately,
in the paternal grandmother's custody. The mother still had custody.
So that part, I think the juvenile court actually gets right. So mother still had custody even through that second incident, which was why there was a problem obtaining the medical care. And then the result of that was that a temporary guardianship was set up by the probate court, giving the paternal grandmother temporary guardianship over this child. Then what happened was there was a problem with the paternal grandmother's home, where contrary to the probate court order giving her the temporary guardianship, the father is actually having contact with this child, and that was not allowed based on the father's criminal record and pending charges. So when the child was removed, she was actually removed from the paternal grandmother's home, not from mother's legal custody at that time. However, I'd like to point out that when a care and protection petition commences by law, it is the mother, not the temporary guardian, who is the defendant in the care and protection case. So that is why, and I think the juvenile court actually understood all that, but unfortunately the findings are not as clear as they could be.
I just don't see, I'm gonna weigh in, I don't see a lot of meat on the bone either with respect to the findings. I've seen, it appears to me that there's some concern about potential drug use, but I don't see a lot of facts about drug use. There seems to be some concern about a mental health issue, but I don't see a lot of facts about failure to comply with mental health treatment or what her diagnosis may or may not have been. I know she's a high school graduate. I know that she was leaving the child with the grandmother. So it just seems to me to be thin with respect to concrete findings of unfitness.
So on the substance abuse issue, I think this was a concern of the juvenile court. Clearly, it's mentioned several times in the conclusions of law. We do know that the mother tested positive for marijuana and cocaine during pregnancy. We do know that she had a chins as a teenager and that there were issues of substance abuse involved in that.
That's alcohol, but yes.
What do we know after she tested positive during pregnancy about drugs?
So from the record, going to the record, it is there's evidence that she is telling DCF that she uses marijuana regularly. She has family members who are telling DCF that they're concerned about her lack of motivation. She's not really doing anything during the day. They're concerned about regular substance abuse use.
She uses marijuana regularly? Or
I believe
marijuana?
Yes, there was concern
at this point than saying I have a couple of drinks.
It's definitely not that she's having a couple of drinks. And again, this is an area where unfortunately the findings are thin, but she
DCF
actually
didn't ask her, DCF didn't require that she submit to drug screens.
No, DCF did not require she submit to drug screens, but they required her to do a substance abuse evaluation, which she did not do.
I agree with that. Now she did one before getting the child back before. Do we know in our record what the outcome of that evaluation?
We do not have that in this record. We do know, however, that she, as I said, asked to do the substance abuse evaluation and does not do it. And I think that was actually important to the juvenile court in this case, because that might have given us some more indication about why she's not doing these other things.
I think it's fair enough to hold that against her. It's not quite not showing up for your urine screen. You know, it's a little mushier than that.
No, but I think, Your Honor, that both the lack of the substance abuse evaluation and the lack of the neuropsych evaluation was important to the lower court, because these are ways that we help figure out what more could help this mother. What does she need? And because she's not showing up to visits, she's not showing up to meetings, she's missing court, something is going on here. And mother's basically failure to cooperate in the process makes it harder to determine what more would be helpful. And I think that was important to this court.
Did mother start to cooperate right before trial?
She engaged in another parenting class and she got back into therapy literally 2 weeks before the trial date.
So is that yes?
In a limited sense, yes. She still hadn't done the substance abuse evaluation, still hadn't done the neuropsych evaluation, missed the last court date before the date of the trial. So yes, in a very limited way, she participated.
Is the child still in the care and custody of TL?
As far as I know, yes. And I would like to speak to that just briefly because I'd first of all like to say there's nothing in this record that suggests that TL is not permanently committed to this child. If there ends up being a question whether she would prefer guardianship or adoption, that's something that the juvenile court can address through the permanency hearings that happen regularly, even after the termination.
But if she doesn't prefer adoption, that seems to me to be pretty relevant to whether or not you have to terminate parental rights, right?
Not necessarily, Your Honor. I believe
that is evident from the briefing is it's one thing to say she's unfit at age 22 with a 4-year-old. It's another to terminate her parental rights, right? And the gist, I think, to some degree of the mother's position is what's the rush? Now, if in fact the DCF can't even tell us right now whether adoption is in the cards, that it seems to me is relevant to the judge's evaluation. I don't see it in here in his findings. He does make in conclusion of law 38, he does do what he needs to do in the sense of saying that there's a reasonable likelihood that her unfitness will continue into the indefinite future, but he doesn't really address that point.
So a couple of things, if I may, I see my time has expired, to respond to that. First of all, like I said, there's nothing in this record that even says that TL isn't interested in adoption. She absolutely was, and she complied with all the requirements to follow through on that leading up to the trial. The other thing is, as to whether mother should get more time, this is the second care and protection for a child who wasn't even 4 years old at the time of trial. And for most of the second care and protection petition, mother did nothing. And so I think it is fair at this point to say those very limited efforts she made right before the trial are not enough. And we need to free this child to allow her to establish in a permanent home with TL, who is loving and consistent and who has committed to being there for this child.
Your time has expired, but I want to just follow up on the first part of your answer. Is DCF aware that she is no longer interested in adoption?
As far as I know, no longer would not necessarily be an accurate characterization. I understand that she asked about guardianship. That is as far as I know.
When you say no longer, you mean she may not have been interested in adoption at the time of trial either?
No. I mean, at the time of trial, the evidence was that she was interested in adoption. After the trial, my understanding from what I have learned from agency counsel is that she expressed interest or curiosity in learning about the option of guardianship. That's as far as I know.
All right, thank you very much. We will hear next from Mr. Ferguson representing the child. Oh, wait, no, you're muted, Mr. Attorney Ferguson.
Thank you.
There we go. Okay.
Good afternoon, and may it please the court. My name is Hugh Ferguson. I was the appellate attorney on this case, and I was also the trial attorney on both of the prior C&Ps. So I can answer a lot of the questions you asked. But to take the threshold issue off the table, I spoke with TL over the weekend. She is absolutely committed to adopting and to raising this child. And at this time, the department is doing their best to help her subsidize that adoption. The reason for that is
there a way to subsidize an adoption or only a guardianship?
There is a way to subsidize an adoption, Your Honor. I'm not sure exactly how it is, but this is in discussion with the department at this time.
And the child is still in TL's home?
Yes, Your Honor, and has been since she was initially placed there.
When was the last time you spoke with your client herself?
I spoke with the guardian or the foster parent on on
No, the
Sunday.
child. When is the last time you spoke with the child?
The child was on the phone for a very few minutes. I have not physically seen her since the pandemic started, though she is right down the street from me.
And did you see her immediately before the pandemic started? I mean, how?
Shortly before, Your Honor, yes. I can walk down to her house.
Okay.
So a couple of things I'd like to follow up on. First of all, the real concern the family had about substance abuse was her drinking, not her marijuana use. And as my sister stated, there was not too many visits that were missed, but the contemporaneous documentary evidence shows that well over 2/3 of the visits with this child were missed, absolutely missed. She didn't show up. She didn't schedule ahead of time. She just
over 2/3, counsel. That's not what the DCF brief says. The way I read the DCF brief is 12 missed against what, just doing it roughly in my head, is somewhere around 40.
I apologize, Your Honor. She attended a little more than half of the visits, 20 out of the 33 scheduled. But these were not sufficient for her to be able to, for the child to be able to build a relationship that would continue outside of the relationship with the foster parent or pre-adoptive parent.
How are we to know that alcohol is the primary issue from the judge's findings?
I don't know from the judge's findings, Your Honor, but in the court reports, there's a number of times where the family has called the department and has asked the department to follow up on alcohol use by this mother.
But do we know whether the court even considered that or took that into consideration? I mean, I see stuff about marijuana. I don't see stuff about alcohol.
I do not know whether the court did or not. And one of the concerns this court has raised is that the findings were slim, perhaps. I can tell you from experience that up through just before the findings were written, we were continually trying to work out a settlement with mother to where there would be visitation over the term.
So I'm concerned you're going outside the record. And I know that some of this you were led to do, and that I don't have an issue with, but I do have an issue with this, as Judge Desmond is pointing out. I mean, there is evidence of her being potentially intoxicated on one occasion. I don't recall much more than that. And under those circumstances, I don't know how we would credit the notion that the concern was intoxication by alcohol.
Your Honor, this was a concern reported by the family.
But it's not in the record, counsel. You're going outside the record. You can't do that.
No, Your Honor, it's in court reports that are exhibits in the record.
Okay.
I will find them and I can forward them to the court, but it is in the.
If they're there, we'll find them.
I'm sorry?
If they're there, we'll find them. You don't need to forward it along to me.
Very well, Your Honor. So at this point, if there are any other questions the court might think that I could assist with due to my relationship with this child, both at the trial level and at the appellate level, I am willing.
If we find that the findings are too thin, but we find there is sufficient evidence in the record itself, but not credited properly by the judge or not, whatever, we don't know what she thought about, or she, I think, thought about it. Do we remand like in Lilith?
I wouldn't think so, Your Honor. I think that even beyond the findings themselves, the actual facts of the case in the exhibits should give the court a clear understanding.
But isn't the judge supposed to find those facts? You call them the actual facts. The way we know what's actual for our purposes ordinarily is we ask a trial judge to find some facts.
I'm sorry, I lost the last part of that.
Normally the actual facts for our purposes are just what the trial judge found, right? Yes. I mean, we don't go through the record to see if there might be other things that, if credited, would count as facts.
I have no doubt that if the court were to remand, that the judge would do a very fair job of reevaluating this. I do not think the outcome would be any different.
Subsidiary facts that support findings that he does make, I think, are free for us on appeal. in the matter of affirmance. Hey, let me just come back because maybe I cut you off too soon. You say that somewhere in the record there is evidence of concerns about her alcohol use. What form does that take? Just where is it in? What kind of document?
It was in the court reports, the 21B reports.
Okay, thank you.
I could send it to the court. I'll find it and send it to the court.
Okay.
All right, very well. Barring
Other
any other
questions?
questions, I see my time has expired and
Anything, we've taken most of your time. Is there anything else you want to tell us on behalf of the child?
I don't think so, Your Honor.
All right, thank you very much. These are always very difficult cases, at least for me, I think for the whole
Yes.
court and for everyone involved in sad cases. So we appreciate the assistance of all counsel in helping us to do our best to get this as close to quote unquote right.
The case is now being recorded.
Good afternoon, everybody. Welcome to the Appeals Court. I am Justice Rubin, and I'm joined today by Justices Desmond and Englander. The next case we will hear, one of two paired cases, is number 19-1784, Valley Green Grove versus Russell and others. We are hearing argument by video conference. As I think you're all aware, this is being streamed live and will also be archived and viewable by the public on our YouTube channel after the conclusion of the argument. We are holding the hearing by video conference due to the ongoing pandemic. The rules of argument are the same, which is to say 15 minutes aside with no rebuttal. I am informed that appellants in this case have chosen to divide their time 7.5 minutes each. And I gather we will hear first from counsel for Gerard Russell, Mr. Fennessy. Whenever you're ready, Mr. Fennessy.
May it please the court. Russell maintains that the lower court erred when it refused to apply the definition of agriculture in General Law, Chapter 40A, Section 3, to determine that marijuana cultivation did not qualify as an agricultural use. The lower court explained its refusal, stating that in its opinion, the legislature had intended to provide, if the legislature had intended to provide a definition of agriculture, it would have amended Chapter 128, Section 1A, or Chapter 61, Sections 1 and 2. In 2016, the legislature amended Section 3, the Section 3 definition of agriculture to exclude marijuana cultivation. In 2017, it again amended Section 3 by adding language indicating that marijuana cultivation was subject to local zoning regulation. In 2007, the legislature added an amendment to Section 3 stating that the term agriculture was to be defined by Chapter 128, Section A, and at the same time amended the Section 1A definition by adding nurseries to the definition of horticulture. After expressing its decision that the legislature did not intend to define agriculture in Section 3, the court's memorandum and order provided nothing more to support its contention. Russell, on the other hand, maintains that the express language of the 2016 and 2017 amendments is evidence of the legislature's intent to define agriculture in Section 3, and represented a continuing refinement of the definition of agriculture that the legislature had began in 2000.
Well, when was the bylaw of Town of Charlton adopted? Well before 2016, right?
Oh, yes,
Okay.
In the early 70s.
Yeah, and I don't remember if the word agriculture appears, but I'm pretty sure it does appear in the bylaw as something that's allowed in all zoning districts, right?
That's correct.
Okay. And at that time, what's your view on whether the growing of marijuana would have qualified as agriculture?
It may have, yes. I mean, it's a plant. It could be grown commercially. I would say that
1970 it couldn't.
Well, I suppose not. I suppose it was more of a backyard activity, but yes, the answer to your question is yes.
The humor here, which is legit, I think, and at one level, is also, I think, quite serious, because I do think that the issue has to do with what's a reasonable construction of the bylaw. And I'm not sure what happens in 2016 really affects that. Just now, I'm not speaking for everybody. I'm speaking for me, because the language that you fix on in section 3 says for purposes of this section. On the other hand, there is a question, I suppose, as to whether the growing of a product that was illegal prior to that time would qualify as agriculture for purposes of the zoning laws. I assume that we don't have anything that suggests one way or another on that, right?
Yes, we do.
What do we have?
We have section 3 that prevents local zoning entities from regulating commercial agriculture.
Well, but that doesn't tell us anything about the regulation of marijuana, right?
But surely that's an interesting point, though. So are you saying, since of course a town could have banned the commercial production of marijuana in 1970, but couldn't ban agriculture, it's something other than agriculture?
Yes.
And always was?
Well, I'm sorry, maybe I misunderstood your question. I thought your question was, could the town of Charlton ban the cultivation of marijuana if it was not commercial agriculture? And I would answer that question, yes. That is up until the 2016 amendment.
Well, it falls within the broadest definitions of agriculture, right? I mean, it falls within what we now have in 128, section 1A, right?
It falls.
Growing marijuana.
I agree that cultivating marijuana falls within the broad category of a commercially cultivatable plant.
So as Judge Foster says, the qualifying language is, for this particular section. Tell me where you think Judge Foster erred in his reasoning.
The section prohibits a local zoning entity from regulating marijuana. Okay, from regulating agriculture. Sorry, and allows the local entity to regulate the cultivation of marijuana. That's what happens in the 2016 and 2017 amendments. Judge Foster looked at that definition and just discarded it, and instead looked to the Charlton zoning bylaw and decided that the Charlton zoning bylaw had, contrary to provisions of section 3, regulated agriculture. And on the basis of that, decided that it had not provided a definition of agriculture. And so it looked to collateral sources to come up with a definition. So Judge Foster was coming up with an implied definition of agriculture based on his interpretation of the Charlton zoning bylaw. And what I'm saying is, well, that's fine, but the Charlton zoning bylaw has no impact. It's irrelevant to whether marijuana is commercial agriculture or not.
Okay, I think we understand your argument. Of course, we're going to be hearing more from you in the next case. Your time has expired. That brings us to Attorney Bobrowski from the Planning Board. And Attorney Bobrowski, I have to tell you, I don't know about my brothers, but I have a lot of questions for you. And if we run over time, I will give counsel on the other side, although of course they'll also get to argue in the next case, but I will give them some additional time as well if they need it. Over to you, Attorney Bobrowski.
Good morning, Your Honors. Mark Bobrowski for the Charlton Planning Board. I'd like to just address a couple of threshold issues first, if I might, and these are covered in my reply brief. First, there was a bit of controversy raised by VGG as to whether the June 13th, 2018 letter of the building commissioner was advisory or whether or not it was an appealable event. Judge Foster ruled that it was not appealable, and I concur. I've attached the June 13th, 2018
Let
memo.
me ask you this. I know you want to do your preparatory things, and I apologize for interrupting. I'm guessing I'm going to get to some of them. Under what authority did the planning board issue its decision?
Under site plan review.
A short answer would be nice.
Under the site plan review provisions of the Charlton zoning bylaw.
This is not a P district, and so the zoning bylaw doesn't actually authorize the planning board to review site plans for this area. Am I correct?
Well, the host agreement that VGG entered into with the Board of Selectmen committed VGG to applying for this site plan
Okay,
review.
but I didn't ask you why they applied. I asked you under what authority the planning board acted.
That's the authority under which they acted.
They acted under the authority of this agreement to which they weren't a party. Is that right?
Correct. Yes.
Has this ever happened before?
Well, I think people submit applications all the time that they're not required to get for various reasons. Sometimes churches, for example, go through site plan review as a member of the community. They're pretty much obligated to behave.
Let me ask you this. When did VGG submit a site plan, before or after the agreement?
I believe it was after they signed the host agreement.
Is that what froze in place the zoning?
I don't know that it's, well, for the purposes of the site plan review, I don't.
The way I read it, counsel, correct me if I'm wrong, but they submitted a site plan review in order to freeze zoning before they entered into the host agreement.
They submitted a subdivision plan in order to do that.
A subdivision plan, sorry.
Yes.
Okay,
And to whom did they submit the subdivision plan?
Planning board.
Does
right.
the planning board have to approve subdivision plans?
Well, the planning board is the authority to do so. In this case, the planning board rejected the plan.
Rejected the plan in the decision under review?
The planning board rejected the plan because it believed that it did not conform with the subdivision regulations it had adopted.
Explain to me why it's a subdivision if it's just about how to use a single parcel.
The VGG folks decided that they would vest their position in the face of a pending zoning change under Chapter 48, Section 6. There's a provision in there that the submittal of a definitive plan freezes the zoning in effect at the time of the submittal.
Have you ever seen that done before, when they also take the position that the planning board didn't have to actually do any approving?
Well,
in order to vest their rights, that is the statutory method to do.
Right.
Well, we'll ask them, I think, about. I'm just a little confused about all of this. So let's just see if we can plod our way through it. Okay, so they submit a subdivision plan with over which, in fact, the planning board has no authority because they're not subdividing anything. And that freezes the zone. Is that right, or am I mistaken about that?
I think you're mistaken about that, Your Honor. They submit the plan for the purposes of the freeze, but they manipulate the plan so that it complies with the statutory definition of subdivision.
How do they do that? Where's the subdividing going on?
I believe they created more than one lot, which did
I
not.
see. So they have, I see. So they put in a subdivision plan that contains more than the subject property of this suit. And they say, see, we're subdividing it, and they're freezing something, but it's not relevant to our current, to the current site plan.
No, in fact, it's a different track altogether. I do not represent the planning board on the subdivision matter, which was appealed by VGG.
All right.
It's
We'll
a
talk
different
about that.
section,
I'm also-
isn't it?
If the only reason that the matter came before the planning board was by agreement of the parties in a contract,
Yes,
and now they decide, listen, we're gonna forgo that part of the contract. Both sides agree, you know what? Forget it. We're not gonna follow suit with that, regardless of what the planning board said.
I don't believe that the agreement was with the Board of Selectmen, and I don't believe that the Board of Selectmen has taken that position, so the contract remains binding as far as I know.
But if they did, because they're gonna argue the other side in the next case, but if they did, then what? Where were we left?
Then the planning board's powers are extinguished because it has nothing in the way of authority under the zoning bylaw to conduct site plan review.
You think the planning board, having issued a decision against someone who has submitted to its jurisdiction and not contested its jurisdiction, that planning board decision can be nullified by two private parties? What's the authority for that?
Well, it's an interesting question. I don't know of any authority for that, but I think in the situation where the host agreement is altered to eliminate the required site plan step, it renders the site plan process moot.
Well, unless by having subjected themselves to your jurisdiction, they now have a definitive ruling that is binding on them, notwithstanding any other private action. But let me keep going. You have suggested that sometimes you do get plans, like from a church, that are not required under the P zoning requirement.
Yes.
When you do so, do they also have to seek a building permit from the ZEO? Is that appealable to the Zoning Board of Appeals? Is the Zoning Board of Appeals bound by what you said in your planning board decision? Or can the Zoning Board of Appeals say something totally different?
Certainly the building permit is appealable to the Board of Appeals. There is a trend in site plan review, and I'm proud to say that I'm pretty much a part of it, in which site plan review decisions of a planning board are appealable not to the Board of Appeals, but directly to court under Chapter 48, Section 7.
I didn't ask you that. I asked you when there is some kind of concurrent jurisdiction because someone has voluntarily submitted themselves to your jurisdiction. And you say, because this is an X district, you have to do Y, and they don't want to do Y, and they go and get a building permit, and then it's appealed to the Zoning Board of Appeals. Do they defer to your construction, or do they just do it de novo? Has it ever happened before?
I'm trying to answer this as best I can. The Supreme Judicial Court in the St. Botolph case said that in the absence of a local provision instructing appellants on where to go with site plan review appeals, the appeal is delayed until the building permit is issued or denied, and then the appeal is taken to the Board of Appeals. That cumbersome mechanism is something I've tried to help towns avoid by prescribing a direct appeal to Superior or Land Court.
You mean in their bylaws saying you may directly appeal a planning board decision under 17A, and your time has expired, but we're not close, I don't think, to done with this. Maybe I'm wrong, but I feel like we're at the beginning. So, and then they bring the appeal as VGG did in this case directly to the Superior Court.
Or Land Court, yes.
Well, Superior Court under the statute, and then it got moved to the Land Court, right?
Either way, towns prescribe both, so.
Oh, okay, so, but that doesn't exactly answer my question, which is you find it cumbersome, and I agree, but is the Zoning Board of Appeals bound? So your statute 7.4.1, 7.1.4.7, which is what one of the things they've bound themselves to in the agreement, says that you are entitled to refuse a plan for failure to comply with the bylaw, which is what happened here. And the hard question in this case, I think there's 80 hard questions, is do we defer to your judgment, or is that for the ZBA?
I think it's deferred to our judgment. I don't think it's the ZBA.
And why do you think that?
Because I think, if I remember correctly, the Charlton zoning bylaw prescribes that direct appeal. It doesn't say go to the ZBA.
But do you have authority to definitively construe the bylaw, or maybe that's just what 7.1.4 means, and when they say we're going to be subject to that, then you're the agency that construes the bylaw in the first instance. And if there's a direct appeal, we defer to it.
I believe that the Charlton zoning bylaw is prescribing a direct appeal to Superior Court.
I'm asking about the standard of review in the Superior Court, not whether you're rightfully here. I think you were rightfully in the Superior Court if you had authority to issue this.
I believe it's a standard Section 17 de novo review where the court hears the evidence and decides whether or not the board's decision was arbitrary, capricious, or should be sustained.
Okay, so that answer says no deference to the construction of the bylaw by the planning board.
Well, the planning board's construction of the bylaw is entitled to deference if it was reasonable. And so that's the degree to which the court should defer.
Entitled to deference if it's reasonable, even under circumstances where another town board, which also has, at a minimum, concurrent jurisdiction, has taken the opposite position with respect to the construction of the bylaw.
What board would that be, Justice England?
Well, I'm sorry, the zoning enforcement officer, so another person.
The zoning enforcement officer deliberately hedged his bets by terming the 3 opinions that he rendered advisory only.
Okay, let's say we agree with that.
Then because he called it advisory, that means that the fact that we have conflicting constructions from 2 different town entities, both of whom at least have jurisdiction to do what they did, we should defer to one and not the other.
Your Honor, I pointed out in my reply brief that the interpretation of the bylaw often falls to a special permit granting authority or a site plan review authority. I cited the Sala case, which
We're
dates
asking
back.
about deference, and deference comes from the fact that the entity that is construing it is the entity charged with the construction under law. That's what our cases say. One could question how far our cases go, because they always say, but we won't defer if it's wrong. We got cases that say that too. But it comes from the fact that they are the party. And one of the things that I think is implicit in that law is that they're the only entity that's going to make that construction. Here, we don't have that.
I think
is there a case where there's ever been a conflicting construction?
Sure, this one, for example.
No, conflicting construction from 2 different entities of 2 different agencies, both of whom are charged with the construction.
I can only indicate that my research, as I've reflected in the reply brief, indicates that, and I don't believe that this is an unusual research result, but both the Sala and the Tanner case, one from Canton, one from Boxford, indicate that when the application is made to the SPGA or to the Site Plan Review Authority, there's no need to go through the building commissioner's office. That would
That's not the question. Let's say tomorrow morning, before we finish doing this, and I'm not advocating this, Attorney Rosen, BGG goes to the zoning enforcement officer and says, geez, we need a building permit for this. And he says, but the planning board said, it's not an accessory use. And VGG is like, I don't care. You decide. And he says, well, I think it is an accessory use. Here's your building permit. Now, to whom do we defer?
The only route there would be to the Board of Appeals.
Okay, so they appeal to the Board of Appeals that afternoon. And a butter comes in and says, this is an outrage. And later, tomorrow evening, the ZBA meets, hears everything and says, oh, our zoning enforcement officer is clearly right. These are obviously accessory uses. It's fine with us. And now we have a final decision of that board as well. Now, to whom do we defer?
I think for purposes of judicial review, it's likely that the cases would be consolidated and the Board of Appeals would argue its position and the planning board would argue its.
And so we would defer to nobody.
No, I agree. You would make your own independent determination, not simply on the status of the board, but on the argument of the board.
All right,
there's nothing
why do
superior.
you, since that could still happen, right? They can go to get a building permit, I suppose. They may violate the agreement, but I don't think there's any bylaw or statute that prohibits them from seeking a building permit.
No, I agree.
Okay, and even though the planning board has said no, they can seek a building permit.
It seems that's the case, sure.
All right, so they go in and do that, right? Since they can still do that, doesn't that counsel that in this unusual circumstance of concurrent jurisdiction, we shouldn't be deferring to anybody?
Well, I think that the case that I cited, the Palulo case, is very clear that the deference is due only if the decision of the board's, the interpretation of the board is reasonable. So whether the ZBA
Either one is reasonable.
I understand
arguably both
that's,
reasonable.
that's the judge's job.
To do what?
So that
To
then
decide
sounds like
whether
no
it's reasonable.
deference.
Okay, but they're both reasonable, right? Because an
do we-
accessory use that is selling 8 gallons of apple cider by the side of the road is an accessory use. But an accessory use that's a cigarette factory might not be, right? So where the line is, you know, a judgment call. So either way might be reasonable. Now we've got 2 reasonable and opposite constructions. What do we do?
Do we
You say
look to
we
the
don't-
enforcement agency? That's my question.
I'm sorry.
Do we look to the entity that has the authority of enforcement?
Well, this isn't an enforcement case, Your Honor. I don't disagree that that's a different status in terms of involving and seeking the interpretation of the building commissioner. This is a straight out application for site plan approval, just like a straight out application for a special permit. The cases that I've cited to you.
But it's not because the application isn't by virtue of the statute. It's by virtue of a contractual agreement.
I don't see the difference there. It's not as a result of a zoning enforcement action. It's as a result of a voluntary decision on the part of my brother, Mr. Rosen, to apply for site plan approval. And so
Can you explain, you said churches do it sometimes.
Yes, I've done it for churches.
What procedure do you use to submit a site plan that isn't in a P zone? Since the bylaw seems to limit the authority of the planning board to P zone sites.
For example, Your Honor, in Westford, I represented First Parish Church. The Dover Amendment protects churches. And in fact, several cases, including Tufts College, Bible Speaks, and my case, Petrucci versus Board of Appeals of Westwood, say that Dover uses are not subject to site plan approval. Nonetheless, we applied because as the First Parish Church of Westford, we wanted a process to unfold that would appear to be responsive to community needs and sensitive to the
Okay,
result.
and then
So
they
we
said
voluntarily
use
applied.
is inconsistent with the bylaw. I mean, if that happens, and I think this goes to both questions from Justice Rubin and Justice Desmond, do you have to appeal that, or do you just leave it on the side because they didn't have any jurisdiction in the first place?
Right.
Once you apply, I think you're hooked. I
Why?
don't think
Why?
because you applied.
Well, no, but you see, you know, there are rules of jurisdiction and whether courts' powers can be invoked. And I don't think you should assume that by agreement, you can create jurisdiction in the courts. And that is the assumption that I keep hearing without really having any case law that explains to me what's going on. And that's part of what both my fellow justices are asking. Can I get to something else, if I might, Judge Rubin?
You take all the time you want because this is going to be a long day.
It's a complicated case. As I understood your argument, Attorney Bobrowski, on behalf of the planning board, you seemed to be taking a position that the decision as to accessory uses was wrong. But I didn't read you to say that the decision was wrong as to the 860,000 square feet that were going to be used just to grow marijuana. Am I misreading your brief?
Yes, Your Honor. I think both our arguments propounded by Judge Foster were wrong. First, it's the principal use of the facility. The planning board's position is that the principal use is manufacturing and processing. And Judge Foster correctly cited Henry versus Board of Appeals of Dunstable for the proposition that this is a fact-dependent inquiry which both compares the net effect of the incidental use to that of the primary use and evaluates the reasonableness of the relationship. So net effect is the test. 860,000 square feet is big, 130,000 square feet for manufacturing and processing is smaller. If you put it on a percentage basis, it's 13% of the facility versus 86% of the facility. But the net effect of the 13% devoted to manufacturing and processing is where the action is. There's 300 people a day showing up at this facility.
But are you asking
to watch
us
the
to
plants grow?
remand? Are you asking us to remand the case because, and I think I agree with this, merely measuring the square footage seems obviously inadequate for figuring out what's an accessory use and what's not. Just to take one example, there's a giant electricity generating plant being put here with 3 cooling towers. It may not take that many square feet of the land, but it's going to be a big deal, I would think, for example. Right? Do you want us to remand that? Or you're saying no, just defer to the planning board?
I don't want you to remand it, Your Honor. I want you to defer to the planning board. And it's not as if VGG didn't admit that its principal use was manufacturing. As I pointed out in addendum B of the reply, their traffic impact and access study, which was prepared by a very competent firm.
Did a traffic study and therefore they admitted it?
Yes, in the traffic study that they generated, table 4, trip generation summary, they say there will be between 664.
Can there be 2 primary uses?
They didn't interpret the traffic generation that way.
Isn't the question, I don't understand why you keep trying to prove that the primary use is light manufacturing. All you have to prove is that it's not an accessory use.
Correct.
Am I mistaken about that?
No, you're right. If you say it's a second primary use, I'm just as happy because it's not allowed.
Oh, okay, but it's
yes. No. See, this is why I asked my question, and I don't follow that. And I've read your brief again, and I still don't follow that.
So manufacturing and processing
make an argument that
are not allowed in the district.
You can make an argument that they're not accessory uses, the processing and the manufacturing. But that, it seems to me, only does away with the processing and the manufacturing, not 860,000 square feet of growing.
I agree.
Okay. All right.
And do you therefore think, I'm sorry, so is it, although the planning board said this is not permitted, it's not permitted because they concluded the primary use was, whereas if we just say whatever it is, it's not an accessory use, then maybe they can come back, come up with a new site plan that has just a farm on it, and then we can all fight about that.
Yes, right.
Assuming we don't agree with Attorney Fennessy that Section 3 prohibits this without a special permit because either the definition of agriculture has never included marijuana cultivation or the 2016 and 17 amendments changed the town and city definition.
Yes, Your Honor.
So let's talk about processing. Let's leave aside, I have this understanding that there's something that people have called processing. And this is all done on a summary judgment record, which I confess I have not consumed yet. But processing includes things like taking the stalks off, getting to the part of the plant that is the part that people want to use for purposes of a product. And then there's something that's called manufacturing, which is extremely vaguely defined at this point, but which I saw at one point included maybe making edibles, which sounds to me like you're not just processing marijuana plants anymore. You're bringing something in and you're making a different product with it. Let's talk about processing for a second. How is the processing part any different than cutting the branches off the top of the apple, crushing the apple to get juice? How is that any different?
I think it has to do not only with the activity itself, and I recognize that Judge Foster used the slaughterhouse case as an example, the case from Natick. But the scope of the activity here and the net effect of the activity here are what I'm trying to point the court to. So the scope is 13% of a million square feet. But more importantly, the people that are arriving at the facility, which generates 600 to 800 plus cars per day, are not coming to watch the plants grow for the most part. They're coming to do processing and manufacturing. That's a lot of cars in an agricultural district in Charlton on some pretty bad roads.
Than apples.
The scope of an apple picking, cider making plant is not 800 car trips a day. The net effect of the apple picking is not the net effect.
Is that in the record?
No. There's the only thing in the record is that VGG has conceded through its traffic and impact and access study that All of these trips are being generated by manufacturing.
And do they say that it's an increase from what currently goes on? Because it is an apple orchard, right?
Yes, but it's a vast increase. Nobody measured the before and after. We just measured the trip generation is folded into the traffic study. The traffic study looks at existing conditions. I'm sure that's a vastly
this
smaller
is
number.
why I feel like we have to or ought to have somebody to whom we can defer. Because the question of when the traffic, when the number of trucks coming in and out, when the everything is so big that we're no longer talking about an accessory use, we're talking about something bigger than that. Seems to me that that's always going to be a judgment call.
Yes.
At some point, right, Philip Morris is growing tobacco and it's all fine and good. And then they say, let's co-locate the cigarette factory right here.
Mhm.
We won't use many square footage because we'll build a 20-story tall building, but it'll be right here, right? That's not quite an accessory use anymore, although maybe a small, you know, let's make samples for people to try with fresh tobacco or something, might be. But I don't know if we defer, and we should get to your brother, but I've dominated this a little much. So
with respect to accessory use, it's not fair to say that Judge Foster just simply looked at 860,000 square feet versus 130,000 square feet. Would you agree with that?
Well, the Judge Foster, as I pointed out, correctly cites the Henry case and then acknowledges that the net effect is an important consideration. In the very next two sentences, he says, well, in this case, it's 860 versus 130,
yeah,
30%.
But he goes on to say that does the marijuana originate on the site? I mean, he goes on through his analysis. I'm looking at page 532 of the record appendix, and he goes on and cites different factors beyond just the size, because we know an accessory use can be bigger in size and still be an accessory use, right?
Right. I think he relies on the Natick case, the Modern Continental case, and he has another case perhaps that I've not jumping to my memory. I cited a case that I thought was more apt. He called Modern Continental apt, but the slaughterhouse in that case was a couple of percentage points of the total operations of the farm, vastly different than here. And the only animals that were slaughtered in that case were grown on the farm. And I thought that a more appropriate case was murder.
the marijuana used here is grown on the farm.
Yes, I understand. But I thought a more appropriate comparison was the home occupation case from Hadley that was decided a few years ago. And the moral of the story is that when it gets too big that the tail is wagging the dog, the use is no longer accessory. Incidental and subordinate mean a certain thing. And there's plenty of cases from Moxont, the airport case from Harvard, all the way through the Henry case that interpret the meaning of the words incidental and subordinate. It's hard to say that if somebody is bringing 300 people in 2 shifts, 7 days a week to the site to process and manufacture, it's incidental and subordinate.
It's hard to say that, but certainly reasonable minds disagree.
Yep, that's why we're here.
Well, it's 300 people on what? Almost 100 acres of land, right?
I don't remember the total acreage, but it's a million
I
square
saw
feet.
94 acres or something like that. Let me ask another question. I'm sorry, and we should,
No, this is important and complicated.
and guy, the other side, we'll give you what time you need to make your points. But is it the planning board's position? You represent the planning board.
Correct.
You don't represent the town, correct? Someone else represents the town?
I'm not town council.
Who we're going to hear from, not going to hear from, I guess.
Not going to hear from.
But is it the planning board's position that the word agriculture in the bylaw does not include the growing of marijuana?
I don't believe that the planning board took a position on that, Your Honor.
So that's a position being advanced by Mr. Russell, but not being advanced by the planning board.
That's correct.
Okay.
I have one more question. It's about the electric plant. I notice that the decision of the planning board doesn't mention the 18 megawatt power cogeneration plant. Is it your position that that is or is not an accessory use, or you don't reach the question?
Planning board did not reach the question. It relied on the manufacturing and processing components to reach its result.
And you don't urge us one way or another on whether that's an accessory use?
I note that it's on some occasions selling 5 megawatts a day to the grid, but I'm not taking a position.
So no one is taking a position. Maybe Mr. Russell will find out in the next case, but
Yes.
but you are not taking that position. Is that because there is a bylaw that allows cogeneration under a certain megawattage as an accessory use?
No, there's a definition of accessory use, and it calls for it to be incidental and subordinate, but the planning board did not make a ruling on whether the cogen facility was.
All right. More questions, Judge Desmond?
Not for now, thank you.
Judge Englander? Thank you very much. This is very helpful to us, Attorney
I
Bobrowski.
thank you. This was a rare occasion to go on well beyond the 15 or 7.5 minutes.
Complicated case, and we will hear from Attorney Rosen now for at least 15 minutes, and I think he gets another 15 in a few minutes. So go ahead.
You're on mute, sir. We can't hear you.
Let me turn the volume
You're
up.
on now.
Much better.
Yeah, we can hear you, but it's very, very quiet.
Good morning, Your Honors. Michael Rosen for Valley Green Grove, Charlton Orchard Group, Nate and Kathy Benjamin. May it please the court. I had a lengthy presentation prepared for you today, and I'm going to take it and I'm going to throw it aside. We're going to do this from scratch. First, I'm going to address Attorney Fennessy. 40A Section 3 is a specific code section. It's the Dover Act. It allows somebody to do something exempt from zoning. 40A Section 1 has definitions. 128, which defines agriculture in our state, has definitions. 61A, which defines agricultural tax ramifications, has definitions. The section that he's referencing specifically says, for purposes of this section, it's nowhere else in the law is cannabis excluded from the definition of agriculture. I think our state legislature.
Well, now wait a second. I was with you right up until that one. How about the law that says that it's illegal to make it or sell it?
So 94G. So because we're talking state law, not federal law, 94G is the law that was passed with respect to the manufacture of cannabis.
Okay, but you're jumping ahead of yourself. 1970, this bylaw is passed.
Yes.
And when it's passed, agriculture is allowed in all districts, as then Section 3 of 40A would require, right?
Yes.
At that time, growing cannabis is part of agriculture?
1970, no.
Okay.
2018, Your Honor, yes.
But this was adopted in 1970.
The bylaw.
Because really, we're construing the zoning bylaw, not Section 3 is supposed to shed light on the zoning bylaw.
Correct. So under 94G, yes, communities could not unreasonably regulate cannabis, but they did have 2 years to adopt bylaws in order to effectuate the results within their community. So they had a 2-year window during which 94G allowed them to adopt bylaws that could further regulate the use of cannabis for all intents and
Does it say
purposes.
further regulate the use of cannabis?
Yes. They could modify and amend their bylaws for a period of time.
I can't, what's the site to 94G?
Mass General Law, Chapter 94G.
Okay. Don't mind, keep going.
Yep.
And specifically, you say further regulate, not regulate, but further regulate.
My apologies. It probably says regulate. I would have to pull it up in front of me.
Oh, well, that's a difference.
It gave communities the opportunity to enact zoning bylaws and ordinances to deal with 94G. It gave those communities a 2-year head start. Mass Planning Commission actually sent out notices to every community and advised them that if they don't act within that time frame, they will be at risk, because if they are a yes community, their bylaws cannot be interpreted in such a way that they prohibit cannabis as it is allowed under 94G.
Wait, retail sales or cultivation as well?
I think all uses generally, all of the categories enumerated under 94G.
So now this is a beautiful segue into my question about section 3. In 2017, another clause was added to section 3. This is provided further that nothing in this section shall preclude a municipality from establishing zoning bylaws or ordinances which allow commercial marijuana growing and cultivation on land used for commercial agriculture. Now, section 3 means one of two things. Either it means, as you say, you can now regulate it if you want, but if you haven't done anything, the burden is on you communities to impose a regulation, because to the extent you allow agriculture, it includes cannabis, and we're not saying otherwise. Maybe that's what it means. Certainly, I agree that the first clause seems to say that, and that's how it was construed, although I have been sometimes unimpressed by the legislature's precision in their use of language. Or maybe, as this second clause suggests, the legislature at least thought, maybe it didn't, but it thought it was shifting the burden. So the pre-existing laws didn't allow it. The municipalities could establish it. And they didn't think that commercial agriculture included growing and cultivation of marijuana. They said that a city or town could allow this different thing, growing and cultivation of marijuana, on land used for commercial agriculture. Why isn't it more reasonable to think that they intended to say, if you want to let there be 1 million square foot farm of marijuana in your town, you may permit it, but you don't already?
I believe the distinction is the application when it comes to yes communities. Yes communities voted in favor, and as a result, the law advocated.
Did yes communities vote in favor of marijuana cultivation?
In favor of 94G. They didn't.
Did they vote in favor of marijuana cultivation?
No, they voted in favor of the entire statute, 94G.
Okay, so the idea, I understand in terms of retail sales and so on, that makes some sense to me, to the extent it makes sense, but it makes some sense to me for there to write two different regimes for different cities and towns. It's a little odd, but whatever. But we're talking about cultivation. It's not just, do you want one of these stores in your town? Who knows who's going to come hang around, blah, 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 whatever. It's, do you want, you know, the character of your community? There's going to have to be armed people around this thing, or electric fences or something. This is not corn. This is weed, right? You better, right? This is a different business altogether. Why isn't it reasonable to think what the legislature was saying was, yeah, you can permit this, establish a zoning bylaw that commits it. Your current one that says agriculture, because they all have ones that say agriculture, doesn't do the trick.
Again, 94G contemplated 5 different potential cannabis licenses.
I'm asking about the amendments to Section 3 in 2016, and then whatever intent was reflected in 2017.
So 48 Section 3, again, is the Dover Act. So any amendment to 48 Section 3 is an amendment that implicates language that could have been adopted that would bring something either within or without.
Okay, let's say they put it in the wrong section because they're not very good at this. But we do have this indication in the next clause that they think for some reason states have to establish zoning bylaws to allow this on ground used for commercial agriculture. Your position is they don't need to establish anything. every town in the state has already allowed it by just allowing commercial agriculture. If the legislature doesn't think that, shouldn't we infer that what they meant to do with the original amendment was change it, shift the burden? You guys can grow, go persuade a city and town to let you.
So again, I think there's two distinct points here. First is, are you a yes community or not a yes community? Under 94G, if you're a yes community, you had a certain time frame within which to adopt bylaws.
With the burden on the town to prohibit. What I'm saying is, since they seem to think that cities and towns need to establish zoning bylaws to allow cultivation on agricultural ground, maybe they think with respect to cultivation, that's not what 94G means. And if it is, they've changed it with these amendments.
So I think under 48 Section 3 in those amendments, what they're doing is they're allowing towns to include cannabis within their farming operations and therefore could be exempt.
They don't have to. I thought you said they don't have to, because automatically the word agriculture now includes cannabis cultivation.
But it's not exempt under Section 3. And if they add it in their bylaw and identify it as exempt agriculture.
But they say you can establish bylaws to allow it. You don't need to. They should have said you can establish bylaws to ban it. But that's not what they said. They said establish bylaws to allow it, implying that it isn't already allowed. And yet the word agriculture appears in every city and town.
So not all of us agree with what Judge Rubin is saying or necessarily agree with it right now. Can we just go back for a moment? Because I have a different question. What is it in 94G that you're relying on? Is there something in 94G that explicitly authorizes the growing of marijuana? And what is it in 94G that you're relying on for purposes of your position?
94G has 5 licenses. One of them is a cannabis cultivation license.
What section are we looking at?
I'm looking at the definitions contained in the Code of Mass Regulations, which is 935 CMR 500.
Now you've outstripped my ability to get that document in front of me. Sorry, counsel. I'm looking at 94G, and I just leafed through it. I've seen parts of it cited, but I don't understand its structure to the point where, and here's the question that's bothering me. It seems to me that the first thing we're doing is construing the bylaw. It seems to me that's what the judge did. He took the word agriculture in the bylaw. He said it's broad. That seems to me to be what the chief enforcement officer said as well. Because it's broad, it includes cannabis. There's another school of thought, which would be it never included cannabis. It was illegal to grow cannabis. And therefore, something had to change in 2016 when cannabis became a product that was lawful in Massachusetts. Now, maybe I'm crazy, but if you're relying on something in 94G, point me to it.
Yeah, I can find that, Your Honor, and if I could brief that and submit that to this court, I will after this hearing. But there were regulations under 94G that required communities that were yes communities to adopt bylaws within a certain period of time in order to impose restrictions. Charlton
in order to impose restrictions.
Limitations.
So if you wanted to limit but presumably that's limiting what has just been authorized by the statute, right? The statute authorizes you to cultivate. So somewhere in this statute, there's got to be an authorization to cultivate marijuana. And then you say, if the town wanted to limit that, they had to take action within a certain period of time in a certain way. And because they didn't, we should construe a bylaw passed in 1970 talking about agriculture as including marijuana.
Correct.
What am I missing?
No, they had 2 years to amend the definition of agriculture if they wanted. They had 2 years to limit the zones within which marijuana could be dealt with under any of the 5 licensing categories, whether it was laboratory testing, manufacturing, cultivation, craft cultivation.
If anyone had come to the town before 2016 and said, I want you to approve the following use on my land, growing marijuana, the town would have said no.
But by the inverse,
Not authorized under our bylaw. Am I wrong?
by the inverse, if somebody had come into town and said, I want to build an 800,000 square foot greenhouse, can I get permits to grow a greenhouse? They could have obtained those permits.
This isn't really a greenhouse. It doesn't use sunlight. It's an indoor growing facility. It uses 18 megawatts of electricity to power it. That's enough for 18,000 houses. But maybe we'll get to accessory use. I don't know if we'll do it in this argument, or maybe we should move to the next case and keep going, but it's up to you other 2 judges. It's not my call, really. You want to keep going here, or you want to call it the next case?
We've hijacked Attorney Rosen's argument. So if there are a few points that you'd like to make in response.
Yeah, I agree with that.
Sure, certainly. So one of the points that you discussed was this theory of dueling authoritative review. When you look at the bylaw in its totality, the definition or the regulation of use does not fall to the planning board under site plan review. Site plan review has a broad provision that says that they can confirm a site plan complies with all applicable provisions of these bylaws feasible to the site. So the town took that provision to mean that it had the right to interpret the bylaw as to use. Now, prior to that, the zoning enforcement officer wrote opinions, and he wrote 3 of them.
If we think they're advisory, do they matter?
If you think that they're solely advisory, they may or they may not. But if you think one of them is not advisory, then it definitely does. So there were
two of them are clearly identified as advisory, and Judge Foster found the 3rd one was advisory as well, although it didn't have that same qualifying language.
Correct. And I think what I'd like to do is, we talked about the development agreement, and the development agreement in its language is what requires us to get site plan review. But in its language, it also requires the town to issue a non-opposition letter. A town can only offer a non-opposition letter for a site if that site complies with zoning for the intended use. So they cannot offer a non-opposition letter for a cannabis cultivation center on this property unless the use is allowed.
Have they issued such a letter?
They have contractually agreed to.
Have they issued the letter?
No, they have not.
And we don't have a ruling from the ZEO, and they can't trump the zoning bylaw in a private agreement. So what difference does that make?
So the town held a meeting, and at that meeting, they had an advisory opinion. And at that meeting, they voted 4-0 in favor of this development agreement contract. The abutters responded, and as a result of the abutters' concerns, they reconvened the Board of Selectmen meetings. Between the first meeting and the second meeting, the ZEO wrote the second opinion. The second opinion was delivered in the Board of Selectmen's forum in an open public meeting and hearing. And based upon that, the contract was re-voted on. And when it was voted on the second time, 4-1 in favor, it was with the ZEO's opinion as to use in front of it. Contractually, my client would not have agreed to apply for a site plan review if the contract had a provision which obligated the town to issue a non-opposition letter, which was an unenforceable provision.
What if we construe what the planning board did? Because all they talk about is the accessory use. To prohibit this so long as it has manufacturing and light manufacturing and maybe electricity generation. But to have expressed no opinion on the growth of marijuana in an agricultural district. Would that be satisfactory to you?
It would not, Your Honor. I think there were 4 components here. There is the actual cultivation and growth of the plant. There is the processing of the plant as it has been cultivated and grown. There is the extraction of oil from the plants, and there is the manufacturing of MIP, marijuana-infused products. I think only the 4th falls under the category of manufacturing. I think cultivating the plant is greenhouse. It's in an 860,000 square foot glass building. It is using the light. It is collecting its own water. It is using that water to feed the plants. It is processing and cultivating plants. Cannabis cultivation, by its definition under Mass law, allows processing. It is then taking those plants and it is putting into a processing room where the flowers are plucked, the stems are pulled, and the plants are separated. It is from there that the flower, the bud, is packaged, stored, dried, and prepared for sale into the marketplace, which is an allowable.
Prepared for retail? Prepared for retail? Or...
Oh. No, it cannot be retail from this location. It has to
No,
go.
I'm asking whether it's been prepared for retail sale. Is it, I don't know how this stuff is ordinarily sold. Is it packaged in 1/4 ounce baggies? Is it rolled into joints? Is it, or is it just giant bales of clean marijuana? What comes out at the other end of this thing?
I would presume it would be packaged in smaller increments and not large bales of cannabis.
Okay, so it's being processed all the way down to retail quantities.
Yes, so that it could be offered to market, consistent with 128 Section 1A.
Can I ask you this?
Yes.
Maybe you'll disagree with this. Altria decides to have a tobacco farm in Charlton. And so they do. It's 1 million square feet. Things are going great. And then they say, you know, instead of shipping this stuff across town to the industrial zone where our cigarette factory used to be, let's put the cigarette factory right co-located in the agricultural area. Can you imagine a circumstance in which that is not an accessory use because of the size or sophistication of the operation?
I certainly could. I mean, I believe the definition of agriculture under 128 Section 1A and 61A Section 2 talks about preparing it for market. And we look at the slaughterhouse cases, modern. We look at some of the ice cream cases.
Okay, but so you're saying that a cigarette factory at a tobacco farm, preparing it for market, is always an accessory use.
No, I'm saying it could be part of the primary use, unless, for instance, they were taking tobacco from another farm.
No. So you're saying a factory of any size. So how many cigarettes are you generating over at your thing? Oh, we make 100,000 cartons a day. You do? Yeah, we do. It's all grown right here. And we have trucks coming and going all day and night because all over America, people love Marlboros. And so that's what we're doing. Our cigarette factory is right here. You think that is part of the primary use of growing tobacco?
I think that's part of the primary use of the definition of agriculture and horticulture under Massachusetts law.
No matter how big the factory is.
If you are preparing your own products for market, that's what 128 Section 1A and 61A Section 2 say.
Well,
the case that your brother relies on with the dressmaker, isn't that contrary to that position right there?
I'm sorry, which
case?
The
case that I believe your brother relies on, a case where the woman's making dresses out of her home. She starts with making simple items. Then she has workers come in, her husband and somebody else, they come to the house, they don't live there, they come there to just as employees. She gets a bigger room in the house to help make the dresses, and she starts making a lot more dresses. And they say, wait a minute, really, it's taken over the home. And so it's no longer an accessory use. But that seems to be contrary to the position you're taking in modern.
I would say it's not at all contrary to my position. In that particular instance, there were residential home in a residential district. They're importing materials with which to make products and ship out of the home. A good example is the Henry case that Attorney Bobrowski cited. They were looking to clear soil and do earth removal, and they were going to do a Christmas tree farm on the property after they removed the soil. The soil operation was going to take multiple years, cost multiple millions of dollars, and in and of itself was going to generate millions of dollars in revenue for the landowner. The court in that case, which by the way was a special permit case, not a site plan case, denied that earth removal use. But they didn't say that the denial of the earth removal use turned the tree farm use into a non-allowed or not permitted use. The tree farm use was not impacted at all. It was this accessory element that was entirely unrelated. Whereas the line of cases that Judge Foster cites deal with—
It has to be incidental and subsidiary. And I don't know how big this operation is. I don't see how a cigarette factory is subsidiary to a tobacco farm. And I don't see how, frankly, I don't see how 3 cooling tower electric generation plant is accessory to growing marijuana. It's not customary, right? Because there is no custom.
Actually, it is customary. It's a Dutch horticultural design. We had a company come in.
How many years they've been doing that for in Holland?
They've been doing it for decades, the company that we have.
Well, in the United States, marijuana is traditionally grown by drug dealers in California with spring guns and barbed wire and armed people around it, and no electric cogeneration plant. So it may be having spring guns would be accessory to growing marijuana. But I don't see that there's a custom.
Sorry, Judge Rubin, if I might.
Yeah.
What do we have in the record regarding the manufacturing component of this proposal? Because I saw the word edibles, and I'm pretty sure that edibles aren't made just with what you're growing.
So in the record at the appendix on page 504, you have a color map layout of the 130,000 square feet that is being referred to as the manufacturing space, which I would call the shared space, not the manufacturing space. In that area, you'll see the offices, the restrooms, a cafeteria, a changing area. You'll see areas highlighted in green that deal with the processing of the plants. And then you'll see 2 areas highlighted in yellow that are the manufacturing areas, as we might refer to them. One, the extraction area, which is the larger of the 2 yellow areas, and the other is the manufactured products area, which is the smaller of the yellow areas. Those 2 areas do not total 130,000 square feet. Those 2 areas don't total 10,000 square feet. They're a little over 2, maybe 3% of the entire project. And as this project was described on the record to the planning board, it was made clear that there was not 130,000 square feet of manufacturing.
Okay, but I'm less interested.
Also,
sorry, counsel.
Yep.
It's helpful to know how much square feet are dedicated. What do we know about what's proposed to be manufactured?
It is identified on page 504, and it is in total 23,000 square feet. And of that 23,000 of it, 18,000 of it includes both some portions of cultivation and manufacturing.
I'm sorry, you're not answering Judge Englander's question, but maybe you've misunderstood it. How many trucks a day are taking things to and from this place? What is the volume of processed marijuana and marijuana products that will be generated every month or year?
Yeah, that's not my question either. I'm going to ask my question again.
Okay, you ask your question.
Yeah, because you can follow on. My question is, what do we know about what they are manufacturing? Do we know what that product is? I saw the word edibles. And the reason I'm asking is because as has been, I think, alluded to. If you're bringing stuff on to manufacture things, that sounds to me like something different than an accessory use. And we have a bylaw that precludes light manufacturing. So I asking the question, what's in the record about what they're making?
There is nothing in the record for what they're making. So if I could explain, the
Well, hold on,
facility.
before you explain, we know the edibles are the chocolate bars, they're gonna be gummy bears, they're gonna be, I don't know what other edibles they have, cookies maybe, brownies. So we know that they're bringing in other ingredients, to Judge Englander's point. The chocolate, the confectionate, the sugar, whatever it is, they're bringing in. They're not making the chocolate on site, right?
Correct. That area of the facility is 5,000 square feet. Of the 1 million square feet, that's 5,000 square feet.
So your position is that even though the bylaw precludes light manufacturing, that use is still an accessory use and therefore allowable?
That would be an argument to touch on in the accessory use portion, no different than the applesauce, apple pies, apple cider, and mead that's being made at Charlton Orchards right now.
I'm not sure. Every one of those things starts with the word apple, doesn't start with the word chocolate bar or gummy bear. And I really think there maybe is a difference.
Again, as a site plan approval, I believe the planning board could have conditioned that the 5,000 square foot manufacturing room be removed. It goes to the question I think you asked Attorney Bobrowski earlier. If we only approve the 860,000 square foot greenhouse, is somebody sitting here saying that cannabis is an agriculture? And I believe the answer was no, the planning board wasn't arguing that. They're arguing that the site as a whole looks like processing. And I do want to correct on the record.
You said you would not be satisfied with a decision allowing or voicing no opinion on growing, but saying they should have done it as a condition. Just say you can't have this and this with it. And then, but if you still want to have a farm, then let's litigate that or, examine that.
Well, certainly a portion of it is what is agriculture and what should be allowed as part of agriculture.
Is that in this case or only in the next case?
I think it's in this case, it's the distinction between Mr. Bobrowski's 2 points, which are, did manufacturing become the primary use? And even if manufacturing is not the primary use, it shouldn't be allowed as an accessory use. So I think that's Mr. Bobrowski's.
No, those both assume that it is agriculture, right? Those assume, the first one is it's agriculture, but that's not what you're doing here. What you're doing here is light manufacturing. And the second is it's agriculture, but this isn't an accessory use to agriculture, right?
I think the argument could be made that this 5,000 square foot room is an accessory use. And the question becomes, is that accessory use allowed or not? I would argue that a cogen plant at 18 megawatts would not be an accessory use. It would be part of the facilities bringing electricity, carbon dioxide, heating and air conditioning.
Do you know of any other farm in Massachusetts, non-cannabis farm that has an 18 megawatt energy plant attached to it? Is that something that's...
I do not, Your Honor.
Do you know there isn't one?
No, I do not know there is not one either.
And the record doesn't tell us anything about this?
No, it does not, Your Honor. All right.
Can I ask another question that you have assiduously avoided answering?
Objection.
How
many trucks?
How many trucks every day taking?
Can we get an answer to the truck question, please?
Yep. Excuse me, Your Honor. So there is a traffic summary here that provides all of that information. It is in the appendix.
How many trucks?
I think it's roughly 30. I'm looking forward in the appendix right now.
30 a day?
Yes.
18-wheelers?
No, not all 18-wheelers. Nope.
What are it's all spelled out in here?
It's in the traffic study.
Does it tell us, therefore, what the tonnage each day of manufactured product is? Can we deduce that from this, or do we know?
I do not believe you can deduce the tonnage of product leaving the site, Your Honor.
Does it tell us how many plants?
The number of plants. So there's going to be 600,000 square feet of canopy, and 100,000. There would be 6 canopies at 100,000 square feet each. These would be leased spaces to 6 different cultivators, 6 different growers, and they would each be producing the maximum allowed under one license. Again, my clients.
How much is that?
I don't know off the top of my head.
Sounds like a lot of weed.
It does.
It is.
It's a giant marijuana farm.
It is a large facility, without a doubt. But to that point, it is 860,000 square feet of it are glass buildings that are built as greenhouse to grow product. I do want to correct a couple of points on the record. One is on the traffic study. There's a comment that we admitted that this was manufacturing. I would say that that's the furthest from the truth. We actually used empirical data, and we actually used our actual projected vehicle trips per day. But because this project was being peer reviewed, and we were trying to ensure that it could safely be accommodated on local roads, and because the town was arguing that it was manufacturing, we took a comparison of the LUC code 140 for manufacturing, and we say right in it, we're using that as a worst case scenario because that is the worst case scenario the planning board asked us.
What page is the traffic study again? I'm sorry.
It's an appendix page. I think trip generation is on page 456, and trip generation summary is page 457.
Okay.
And it is not 300 people working in the manufacturing facility. There are 300 employees in total. 15 of them are security. 35 of them are office staff. That's the first 50. Then there are 300. Of the remaining 300, 50 are manufacturing and 50 manufacturing and 200 are cultivation and greenhouse. So the employees, roughly a sixth of the employees, not the majority of them, work on what Mark would qualify as manufacturing. And that manufacturing would include all of the processing activities that are taking place inside the green portion of the facility shown on page 504 of the appendix. So again, our belief is the majority of this is truly part of processing of a cannabis plant. Yes, there's incidental. There are 5,000 square feet carved out for manufacturing on the theory that one of the tenants wanted to make MIP, manufactured infused products.
All right. We've done this for a long time. We have another case that maybe is the same case. So why don't we move to that now? And we'll see if anything is left hanging at the end of that thing.
May I speak?
Yes, of course.
This is Attorney Fennessy. May we have a couple-minute bathroom break, please?
Yes, why don't we do that? It is 1:39. We will return, get up and running and see if we can wrap it up. I will say, this has been a very helpful argument. I'm sorry about the length.
Oh, wait.
Wow, that's troubling.
It is troubling.
Hi. Oh, goodbye.
Did we get bombed there?
Exactly. It's like clockwork.
Is that a Zoom bomb?
We are live and we're recording.
The case is now being recorded.
Good afternoon. Welcome back. Our final case for the day is paired with the previous case. This is 19-1516, Benjamin versus Russell and others. The rules are the same on video conferences in the courtroom, 15 minutes per side, and there is no rebuttal. And of course, we are doing video conference because of the ongoing pandemic. We will hear first from Mr. Fennessy. Oh, there we go.
Okay.
I don't know what's left, but you tell.
I don't
us.
know where to start. I guess my view of this case is that the issue of defining agriculture is not in the zoning bylaw or any derivation of a possible bylaw, but is in Section 3, and that as I said earlier, I didn't think that.
Aren't we construing the bylaw? Help me with that.
I don't know. I think that's a red herring, actually, because the Section 3 prevents the regulation of commercial agriculture. So, and this is certainly commercial agriculture. If that's what they claim it is, it's commercial, and that anyway.
No. Section 3 says, as used in this section, the term agriculture does not include marijuana. That's all it says.
That's right.
So how does that? You just said Section 3 prevents the use of the cultivation of marijuana.
I'm sorry, I misspoke. Section 3 prevents the regulation of agriculture by a zoning entity. I'm sorry, I misspoke.
Yes.
Section 3
include marijuana.
Section 3 also states that the term agriculture or horticulture does not include marijuana cultivation.
For purposes
and then it goes
of
on
this section. Yeah. For purposes of the Dover Amendment.
Well, it's in the Dover Amendment. The Dover Amendment is Section 3, and Section 3 says municipalities can't regulate commercial agriculture. So it's for purposes of the section, but that is the only section that says that, and that is the only section that prohibits municipalities from zoning regulation of certain subjects, including commercial agriculture. So just because it says for the purpose of this section, yes, but this is the only section there is. So
no, I don't follow that logic at all. I'm struggling with that logic. I mean, you have a general grant to zone, right? And
yes.
Then before that, people could do whatever they wanted. Then you had 40A comes along and says, no, we're going to regulate the use of land. But when we regulate the use of land, you can't regulate agriculture. And then
that's right.
In 2016, they say, but you know what? Agriculture doesn't include marijuana. Marijuana, you can regulate. And then that gets to the language that Justice Rubin has been focusing on, where they use the word establish. And does that mean anything? But there is this question as to whether that has anything to do with the bylaw. And that's why I started with the question, aren't we construing the bylaw?
No, you're not. And the reason you're not is that the legislature has superior power to municipalities. Legislature has the right to reserve to itself the authority to regulate, has authority to change the ability of towns to regulate, and that was decided in Board of Appeals of Hanover versus Housing Appeals Committee.
Sure, if it acts to preempt the town, but that's not my understanding. I thought this case, maybe I'm mistaken. I thought this case was about whether or not under the town's bylaws, the proposed program, for lack of for the best word I can use right now, the proposed use of 1 million square feet was lawful. was to be approved
Right.
by the town. Isn't that what the question is?
The question is whether that use is an agricultural use or it is not.
And whether it's permissible by right, right?
That's right. Whether it's permissible, if it's an agricultural use, then it's permissible in an agriculturally zoned area, and all of the town
Under the town's bylaw.
under the town's bylaw. Right,
So we're
right.
construing the bylaw. What is an approved use under the bylaw?
Well, that's where we separate. Section 3 prevents the town from regulating commercial agriculture. If you're prevented from regulating commercial agriculture, seems to me you're also prevented from defining it. So the definition that the planning board relied upon was a definition in Section 3. And I think that's the way they understood it. That's certainly the way I understood it.
Can I ask
So,
you, your brother
And
said,
Judge Foster looked at the definition of agriculture. He looked at other statutes, as the appeals court has done, and he looked at the Black's Law Dictionary or the law, Webster's or Merriam, whichever it was, to determine what he felt was the appropriate definition of agriculture, correct?
that's what he did, but I'm suggesting to you that this was a fiction. This is a fiction because the town didn't regulate agriculture. It couldn't do that under the provisions of Section 3. Section 3 said you can't regulate commercial agriculture. So if you can't regulate it,
Purposes of exemption.
they set up an agriculture.
well, the exemption is one way of describing it. Prohibition is another way of describing it. Okay, they're exempt in some senses, but they are prohibited, and the legislature is the superior power. It has the right to regulate.
Counsel, are you really arguing that we should ignore the word agriculture in the bylaw? To you, as I'm hearing you now, it's irrelevant. They couldn't regulate agriculture anyway, so it didn't need to be in there, and we shouldn't be construing it.
Well, it needed to be in there because if it wasn't in there, it was by virtue of the construction of the zoning bylaw, it would have been prohibited. Either it's specifically allowed or it's prohibited. So that's why it was there. They weren't trying to defy.
You have to define the word, right?
You have to define the word.
I mean, now the word, okay, now I've reached a point where, okay, you just told me the word agriculture needed to be in there. So now we have to understand what agriculture means. And I think that's what the question is in the case. Is marijuana within the scope of that word?
Yes, but
as used in the bylaw.
But wait, are you saying, Attorney Fennessy, are you saying it can't be regulated in any zone? In a residential zone, you can do agriculture. In a business district, you can do agriculture. That's what the Dover Amendment says. You've also created an agricultural zone, or the town has created an agricultural zone. Okay, so here's all the different zones. When they amend Section 3, suddenly you can't grow marijuana in a residential zone anymore. You can't grow marijuana in a business zone anymore. You can't grow marijuana in a industrial zone anymore. You can do any other kind of agriculture, but you can't grow marijuana because they've said that's not included. And you're saying, and you can't grow marijuana in an agricultural zone anymore, because really all they're doing, they're not defining agriculture. They're saying whatever we're not allowed to regulate under the Dover Amendment is what's permitted in this zone.
That's exactly what I'm saying, yes.
Let me ask
and
you.
I would also,
am I mistaken? Is part of this farm on a zone for commercial business?
A little section on Route Route 20, yeah.
And what under the plan, I'll ask your brother as well, what part of the thing is going on there?
Nothing.
I don't think
No,
any.
we'll ask you when it's your
Oh,
turn.
I'm sorry.
Okay.
I thought you were asking me now.
My
My
mistake.
apologies.
What is in that part?
My impression is nothing.
I don't have the bylaws in front of me, for which I apologize. I tried to find them and did not jump out at me where they are in your record. But in any event, do the bylaws say that agricultural uses are allowed in residential uses?
And yes.
So they do.
Well, it's a table, and they're all.
So it is there for every one of those uses.
But it has to be. But it has to be.
I understand.
Let me ask you this. Why isn't this case moot?
Why isn't the case moot?
Well, your client
I guess I missed something. I don't know why. Why would it be moot?
Well, I understand from a motion that your client has moved out of Charlton.
He has a successor in interest.
Well, he has
a
successor in his interest as an abutter. He was allowed.
No, as a property owner. As a property owner.
He was allowed.
He sold the house. The present owner of the house is a successor in interest.
Do we know what their position is on this matter? Do we know if they
Their,
want to?
their position is they're quite happy to have Mr. Russell complete this process.
Well, shouldn't you have to substitute them as a party or something?
Rule of Civil Procedure 25 indicates that he can continue as long as he.
What about the rules of appellate procedure? This being an appellate.
I didn't find any rules specific.
No,
to this
there's a rule.
Yeah.
But I don't think you're right about what you're about to say about Rule 25, sir.
It says it's may.
Can I? I'm sorry. Go ahead, Ken.
No, go ahead. Go ahead, Justice.
Who do you represent as you're standing here today?
Russell's successor.
You represent Russell's successor. Do you have a name for that person?
Yeah, who is that person?
And do they know it?
Did they hire you?
Do.
Did they hire you?
No. The way the rule is written is that an original party can continue his representation for for the benefit of his successor in interest, unless the court orders that successor is joined as an additional party or a separate party.
Counsel,
so
I
that's
think
as far as
you
it's gone.
overstated the law, counsel. Let me, if I could. And this is troubling to me now because this is not something to be taken cavalierly, okay? There's a case called Mahoney against Haverhill that was decided by this court within the last few months, that was cited in the briefs. I'm very familiar with it. And it holds that someone who no longer has a stake in an effort to get a building permit, their case is moot. Now, the particular judge who wrote that might have been better off using the word standing than moot, but the person who is going forward has to have a stake in the outcome of the case. Now, as I understand it, Mr. Russell doesn't live in Charlton anymore.
That's correct.
Okay. So the person you represent here to have a stake, it seems to me, has to be a person who is in Charlton. Would you agree with that?
Or on the property?
Well, Your Honor, I obviously read Section 25 differently. The succeeding owner could be joined, but hasn't been joined at this point.
Okay.
So that's where we stand, and I leave it to you to decide whether it's moot or not.
Does the successor? Did I hear you say the successor in interest favors VGG?
No, the successor does not favor VVG's development directly across the street from our house.
Okay, so this person lives directly across the street from the development.
Do they live
Yeah.
there or do they just own the property?
No, they live there.
And you're suggesting that now that we've had a discussion about the rules, that this person could be substituted in?
Yes.
Okay. I believe the rules do allow that to happen. I don't know how my brothers feel about that, but I do think that that's something that needs to be sewn up and not simply represented to, during argument. So I leave that to you.
Let me say something
So
further.
short of that happening, isn't it moot?
We have cases, published cases, I think, where someone has died during the pendency of an appeal, which you might think would moot lots of cases. And we have said, we have given the parties an opportunity after filing a suggestion of death to substitute the estate after checking with the personal representative or executor to find out whether they have any interest in pursuing the litigation. Litigation can cost money. Litigation can take a position that is antithetical to your position. So I don't know all the law about this, but I would think you'd have to take some step like that. And then let me also add, my understanding of the basis of Mr. Russell's standing is not merely that he is an abutter, the person across the street. Maybe that would be sufficient. And so it may be that you just want to find out if the person living there now wants to be substituted as a successor in interest. I thought he also intervened on the ground that he was one of the leaders of this movement to amend the bylaws without, through town meeting, rather than through a referendum. Now, maybe that, since that issue is out of the case, maybe that doesn't give him standing anymore. Maybe his standing is as an abutter. I have no idea. But whatever it is, figuring out who's actually a successor in interest seems like it would be important.
I certainly can address this issue. I will either file a motion to add her, the succeeding owner, as a party in interest, or if she declines, then I will inform the court.
All right. Why don't we say, I don't want to speak for the whole panel without asking them, but get us something within a week? That's
fine.
Reasonable to both of you, so we can figure it out. Your time has expired. I think we really understand the arguments in this case. And we will hear now from your brother, Attorney Rosen.
Actually, Your Honor.
Oh, no. What?
I'm the designated VGG counsel for this portion of the case.
Maybe you can tell us whether VGG LLC is bound by a decision in the other case or not, if this one is moot.
That's an interesting question. It's obviously the cases have been for purposes of the issue of allowed use. The cases were consolidated for that purpose by the lower court. So to the extent that the summary judgment affects both of the entities equally, I suppose it wouldn't render that piece moot to the extent that the planning board still has a claim. To the extent that Russell independently was making a claim, then that would be rendered moot.
So this case would be moot because the planning board's not in this case.
That's correct.
But you would still be bound by the judgment in the other case to the extent it was about not a declaratory judgment, but about the planning board decision. Well, we've lost your audio has.
Lost your audio.
I don't know why. I know, it looks like you're not muted, and yet.
It perhaps.
May have timed out after an hour and a half. It may have timed out after an hour and a half.
Seriously.
It's a great question. I think procedurally, the planning board, I suppose, could have moved to intervene in our case as well. But to me, it's a distinction without, I suppose, a difference in that the summary judgment did affect both parties equally. To the extent that there are separate issues in this case, there were separate issues in this case, but those were not appealed.
So is there anything you have to add on the merits to what your brother Rosen said in the last case?
Yes, I believe so, because, in trying to prepare who's going to be responsible for what piece of this, I think more of the 94G Dover Amendment section kind of fell on my plate. So if the court would oblige me the opportunity, and I will try my best not to retill any plowed ground. But with respect specifically to the issue of the Section 3, and I see the court going through the exercise of whether or not Section 3, as my brother said, precludes a town from regulating cannabis. And it expressly states the opposite, which is exactly what Justice Rubin found in the amended language to 94G, which says that nothing in this section shall preclude a municipality from establishing zoning bylaws or ordinances which allow commercial marijuana growing and cultivation on land used for commercial.
But why doesn't that imply that they have to establish something in that pre-existing agriculture ordinances? And whether you get there, Justice Englander and I construe statutes a little differently sometimes. So he's saying when it was originally adopted, if I can use the word original, it didn't include marijuana, so it doesn't now. I'm not sure I would say that, because I might say, well, any plant that you can grow legally.
I'm not sure I have said that, but go ahead.
You haven't said it, but he might say it. And I might say, it says agriculture, so if you can grow the plant legally, then it's agriculture. But it seems to me the question is, did the legislature intend to shift the burden to those wanting to allow to have to change pre-existing agriculture bylaws or not?
No.
And, I hear you say that.
And I'll explain why.
Great.
First of all, the statement in that section says that towns shall not, it says nothing in this section shall preclude a municipality from establishing zoning laws. It doesn't say
every municipality has agriculture in it, probably some agricultural zone. I don't know about whatever does Brookline, I just don't know. But my guess is almost every town has agriculture in it. And in the past, since they can't prohibit anything, there's no prohibitions in those bylaws because you couldn't enact one under the Dover Amendment. There was no kind of agriculture that you could prohibit.
Presumably they could have had a zoning law that said we prohibit the growing of marijuana, but I don't see anybody adopting.
Okay, they didn't have to do that. So
psychedelic mushrooms or whatever else. What were you explaining?
So as of 2016, the world changed with the passage of 94G. So when that came into law, there was specifically on Section 3 of 94G, it sets forth exactly what a municipality must do to, in fact, preclude or prohibit or restrict or limit what is then deemed legal. And to Justice Englander's question as to where in 94G does it say that cultivation is no longer, subject to arrest, that's in Section 9, subsection A2, where it deals specifically and states that someone who cultivates cannabis is not subject to being arrested, etc. So it made that license holder
So
now.
it's a backhanded legalization because it says you can't be arrested for doing this anymore.
Essentially correct. That's
So
right.
when somebody says this legalized the manufacture of, or the cultivation of
Or
marijuana,
decriminalized,
what
correct.
it decriminalized it. So that's what I should look to for that. And then you go back to Section 3, and it talks about what you have to do to regulate it.
To not just to regulate, no, to limit or restrict. So it's very specific.
Using it the same way.
Okay. Under the appellant's
Wait. But the amendment I'm talking about, so first of all, the First Amendment, the 2016 amendment that says this is not anymore required to be permitted, or this is not required to be permitted. Is that part of 94G or that's a subsequent statute?
Can you state that again, Your Honor?
Okay, so there is the language saying that for purposes of this section, agriculture doesn't include cultivation of marijuana.
Correct.
Is that part of 94G or is that a subsequent enactment?
That was in response to 94G, because 94G, everyone would have thought, what we had with 94G was a legislature who came out to say that from now on, the cultivation of cannabis, among other things, is decriminalized. And
But
so,
still unlawful.
no, I would not say it would still be.
Why are you saying decriminalized instead of legalized? What's the difference?
Okay, then legalized. I'm not trying to create a distinction there. It became lawful to do these things. And so what they anticipated was, because it was so clear to most that cultivation of cannabis could be considered agriculture, they said, well, you know what, for that Dover Amendment, we need to square, we need to make sure that these two laws are read harmoniously. So in order, because we just came out with 94G, which says, here's how you zone cultivation of cannabis, we need to make sure that people don't think that they're exempt from that. And so we have to go amend Section 3 of the Dover Amendment to say, you're not entitled to an automatic exemption for cannabis cultivation. You still have to follow the mandates of 94G. And so it would be treated at that point in time like any other lawful activity.
Okay, so your view is that the meaning that, in fact, what is revealed by the 2016 amendment is that everyone thought, I'm sure that isn't quite right, but that the legislature thought agriculture, unless we put this in, it includes cannabis cultivation. Now we better put this in so they know they can regulate, right? They know they can now prohibit it if they want to, right? Under 94G, they have to do it certain ways. You say that's not quite before us. All right. But then what about the next amendment? Well, what about the amendment that says, because every place had agriculture allowed, so suddenly marijuana cultivation is available everywhere in the state. It's lawful in every city and town. But so they don't have to establish by zoning, establish a zoning bylaw which allows it.
Does this only apply? I'm sorry, does this only apply to yes communities or no?
This section applies to yes communities until, I believe it was December of 2019.
Wait. Yes and no communities both had to put in a ban. Yes communities had to do it by referendum. The default position, your view is, after 94G in this amendment was agricultural, this is allowed in agricultural zone places, absent a change in the law to prohibit it.
Correct.
But the legislature said that cities and towns could affirmatively allow it. They didn't have to.
No, it doesn't say that, Your Honor. That's not a correct reading of the language in that section. I respectfully would say
Nothing
it
in
says
this section shall preclude a municipality from establishing zoning bylaws or ordinances which allow.
It shall not preclude. That's the key. It shall not preclude them from doing it. It doesn't say they affirmatively have to do it.
Understand, but it says that, of course not. It says they can allow it.
Mm-hmm.
The negative implication of which is they need to do something to allow it.
Do we have any legislative history on that? I had not focused until Judge Rubin just pointed it out, that those two sentences came in 6 months apart. So the first one comes in almost, as you've described, I think accurately, almost entirely on top of the legalization of marijuana growth. In December of 2016, they say, oops, we got the Dover Amendment. We better make sure the Dover Amendment isn't read to mean that you can grow marijuana wherever you want to. Then you get 6 months later, this sentence that we're talking about. Do we have any history on that? Why was that enacted?
I don't have that. There may be. I have not looked at that, Your Honor. But I think the converse question to ask would be that under what Justice Rubin is suggesting, or what appellant may interpret, if the Dover Amendment would be read to say, okay, cannabis can never be agriculture and therefore it can never be subject to zoning, then how can you marry that with 94G's affirmative requirement for yes communities to go through the two-part enactment and then bylaw passage in order to
Because it
prohibit.
was enacted
That's
after.
a question
Why
that
would
one
they
we're
do
going to
that?
have to grapple with, perhaps.
It was enacted after 94G. Both
But
of
again-
the changes were enacted after 94G. I have found a little legislative history of the first one that suggests that what they intended to do, although I understand it's just legislative history, was to make it so that cities and towns had to approve in order to have cannabis grown. They didn't want it to be automatic. I understand they didn't write it that way. I certainly have, you know.
Well,
I think any reading of 94G puts that burden to restrict or prohibit on the town to affirmatively go through those steps. If they did not do it, then it would be treated like any other lawful use. And that lawful use in this case would be indoor commercial greenhouse growing, and would be agriculture under the bylaw definition in the town of Charlton. I mean, towns with a prohibitive form of zoning could have just done nothing and then just relied on the Dover Amendment to prohibit cannabis establishments from otherwise allowed uses. And
Yes,
that's contrary.
Not establishments, not all cannabis establishments, cultivating and growing. Right?
Well,
I mean, by and large, when people think of cannabis establishments, they're thinking of dispensaries.
so is that another way of saying, boy, this is fun. So we had this bylaw from 1970, but I'm not going to dwell on that because Justice Rubin doesn't like that.
No, you can.
Instead, I'm going to say we had this bylaw that defines agriculture.
Yes.
And agriculture is broadly defined. And in fact, it's even broadly defined in the amendments to the Dover Amendment that we're talking about because it refers to 128, chapter 128. So what you're saying is, look, anybody in Charlton, once 94G is enacted, now knows that you can cultivate this herb. And therefore, since it falls within the definition of the word that's used in the bylaw, if you want to stop that, you have to go through the 94G Section 3 process.
Yes.
That's your position, right?
That is correct.
Okay.
I think we got it.
If they had intended cannabis to be considered agriculture for purposes of zoning, then they would have amended the definition in that section, in section 1 of chapter 40A, which applies to the whole chapter.
Always so good at doing what they're supposed to do with any precision. That actually, I mean, we'd be half out of business if they were good at it, you know, but.
Can I ask, I'm sorry.
Sure, go ahead.
I know I'm prolonging this, but can I ask another question?
Please.
So one of the arguments that Mr. Russell's successor makes is this is preempted by federal law. That you can't issue this permit, Town of Charlton, because federal law says that what you're issuing the permit for is a crime. What do you say to that?
Well, first of all, that issue was never specific.
They say it was. They say it was raised below. He says it right in his brief.
There were amicus briefs that were submitted which raised it, but Mr. Russell, however, did not. It was raised in the context of the other summary judgment dealing with the zoning bylaw versus the general bylaw. So to that extent it was, but that summary judgment decision was not appealed by Mr. Russell. Nothing with the use issue implicated this federal constitutionality question. So that's why I say it was not raised in the lower court in the context of what's currently being appealed. Here, and I guess even if it was raised, I'm happy to address it. He's suggesting that somehow the Controlled Substances Act preempts Chapter 94G. But the supremacy.
Well, no. Be careful about how you formulate the question because it's too easy to formulate it away. I think the best way to formulate it is to say the Controlled Substances Act preempts any law of Charlton which would grant a permit to someone to cultivate marijuana.
Or to sell it. And every dispensary in Massachusetts would be closed.
Well,
but in fact, since one can comply with both laws, not that VGG is, but one
can
can
you answer
comply.
my question before you answer my question,
I'll
please?
defer to Justice Rubin's answer.
What
Okay.
you want my you like my answer?
You adopt Judge Rubin's answer. You don't have anything more?
Well, only to say that it's still not, there's no private right of action under the Controlled Substances Act. So it's really,
Yeah,
it's
I
not.
saw all that stuff and I was struggling with it because I think that it's just a claim under 240 to say, you know, that this, give me an order that says that this is inconsistent with the bylaws. It's inconsistent with the bylaws because it's not allowed. It's preempted by federal law. Anyway, I get all those points. I also get the point that, as I understand it, federal law has not been enforced in Massachusetts since the adoption of this law. So it's hard to see how you would say that something is preempted by federal law where federal law is explicitly not being enforced.
Well, but that's just discretionary, isn't it?
Am I right that it's not being enforced?
You are, yes, Your Honor.
What about the 28th?
They say that's a result of lack of funding. At least that's what they said in the amicus brief. But they say that could shift at any point, right? So that still makes it wrongful.
By the way, you vanished, Judge Desmond, so it's a little ghostly here to hear your voice and see the empty courtroom.
Where'd I go? I'm still hearing
I don't
spirit.
know. There's a specter haunting Europe.
I don't know what happened. I'm still hearing spirit.
You sound very
There we
smart.
are.
I can't see you.
All right.
Your Honors, there's just one other issue that respectfully I was hoping to address with respect to what Mr. Russell specifically has filed here and what the summary judgment was based on. And it deals with the site plan approval issue. And here, Mr. Russell filed his cross-claim in November of 2018, which was months before the planning board ever denied the site plan. So Mr. Russell put forward under 240 section 14A his claim, which was based solely on the advisory opinion, as he deemed it, of the ZEO of the building inspector, who said this was an allowed use. And I think that's noteworthy because as we've been talking about, and the court was talking in the last case about deference to be afforded to a board or panel or a local, whatever the bylaws say to the individual who is granted that responsibility to do, that should be kept in mind because here it wasn't, according to Mr. Russell, the planning board. It was the zoning enforcement officer.
Isn't that a ripeness problem?
Pardon?
Isn't that a ripeness problem? I brought a declaratory judgment against an advisory opinion. Doesn't strike me as like the closest meeting of the issues, right?
No, but I do think what it does tell us, Your Honor, is that the real question here was whether or not this was an allowed use. And even under Mr. Russell's interpretation, the party who was responsible for making that determination was the zoning enforcement officer, not the planning board. And the
Except
planning
that you
board
submitted to the jurisdiction of the planning board under 7.1.4. I don't know why you did that, and I don't even really understand how you did it, but it seems like you did because it says that in the agreement.
I would draw the court's attention to the summary judgment record, specifically the affidavit of the building inspector, who gives a very thorough.
I'm not interested in his subjective idea of why this was good.
Not why it was good, but essentially what that process was. And I think the process was just like it has been stated by this court. This court talks about what the role of a planning board is with site plan approval, and it's to impose reasonable terms and conditions on the proposed use. It's to regulate.
Chapter 7.1.4.7A1, which says, does this comply with the zoning bylaws as feasible here? I mean, I hear what you're saying. It seems, I mean, look, if this were a P district, this would be a lot easier, I guess. But it's not, right? There's this mismatch between what you've said you would undertake and the way the zoning bylaw is structured in terms of who we defer to. It's really complicated.
I suppose, but it never would come before planning in that instance if it wasn't an allowed use as of right.
I agree, and yet you subjected yourself to the planning board.
To the process, not to the ultimate determination to deny.
Under standards.
If that's true, how could you even appeal?
So can you and can you and VGG decide to just ignore?
You and the
ignore.
city.
I'm sorry. Can you and the town decide to just ignore the planning board? You agreed to go in there voluntarily. You didn't like what they said, so you can agree by contract. Hey, we're going to overlook that piece by agreement and go forward.
I think the point, Your Honor, which harkens back to a different question asked previously, was whether or not we could just apply for a building permit and go forward.
Right.
And ignore what the planning board said. It really would be a decision that would be left to the zoning enforcement officer, but that's not the path that we currently have chosen, because we feel very strongly that as a matter of contract is different than as a matter of statute. That you don't confer based on contract jurisdiction, that it must be something that is legally. Is the planning board under that bylaw charged with making a determination of use? And in this instance, the only one in the town of Charlton who is charged with that responsibility is the zoning enforcement officer, which is Mr. Meskis, the building inspector.
And he says he thinks it's okay.
And he said it thinks it's okay.
Again, why is Judge Rubin misreading that part of the I think it's the zoning bylaw that suggests that in fact part of the determination the planning board can make is whether or not the use is appropriate?
I think
am I misreading that?
In the scheme, meaning of all of the criteria that the planning board can take into consideration, it can certainly take into consideration what the ZEO has determined in terms of the use.
It doesn't say that.
That's not what it says. And he hasn't made a determination because you say it's advisory.
No, I don't, Your Honor. I specifically would say that the June opinion is not advisory. And how do we know that? Because this building inspector knew how to make an advisory opinion. And
yes, but no one applied for a building permit. It was presented to the town at their request. I don't know what
it's even worse than that. The June document incorporates his earlier statement that it's just an advisory opinion in March. So what you're saying is he needed to repeat himself twice.
No, Your Honor, I disagree respectfully. What he did in that June opinion is said, in March, I was asked to give this, and I gave an advisory opinion. You've now asked me to that said this was as an allowed use.
And it was advisory.
Correct. And now you've asked me to opine a second time.
Sorry, Mr. Rosen. No, we can't. We're here from the Croft. Sorry.
All right. I understand the argument.
And it's in the brief. All right, gang. I think we are. We seem to have gone over time. My mistake. Thank you very much. I can't believe I'm saying this, but this hours-long argument was very useful. Really, very, very useful. This is obviously a complicated and important case, and we will give it all the attention it deserves, which is our full attention. So thank you very much, counsel, for indulging us and staying this long. The case is submitted.
I'd like to extend my thanks as well. It's a long argument, but it was a long argument because it was necessary. And thank you very much for your attention and
patience. Much appreciated.